Supplementary list. Pronouncement of judgment. Item number 1.
Yes. Acquiescence is writ large in instant case, coupled with the fact that the non-grant of additional increment is not a continuing wrong, with the coming to force of fresh pay revision by way of subsequent recommendations under the 7th Central Pay Commission. Further, as noted earlier, the release of required amounts by the MHRD and the chapter having been closed, reconsideration of the claims of petitioners will necessarily entail an exercise involving the fresh release of amounts under a lapse scheme on a claim which should have been brought before the court at least 12 years ago. The fault being squarely in the shoulders of the petitioners, the leaves as spread, therefore, in considered view of this court cannot be granted at this late stage. The point raised with regard to UGC regulations 2010 being a piece of subordinate legislation and therefore inviolable is noted, but the law and its application will have no application in the instant case, as not a case of violation as much as the same was being implemented, albeit the irregularity that has been highlighted the writ petitioners belatedly by his writ petition. The judgment placed by the petitioner so-and-so will have no application with regard to qualifications for appointment of Vice Chancellor. The other judgments being of limited application are discussed, accordingly discussed about the petitioner's case being hit by delay in laches. Whatever rights derived from the scheme are no longer available to them. The petitioner therefore not entertained, and the ground alone stands dismissed.
Any mention?
Lordship, this item number 10 with KP, that Elias Marvin, the case.
Who's KP?
Regarding that person
Mr.
was...
Barasaji, what do you mean by KP?
Okay, with KP, because the court has asked me to...
What do you say again?
Find out
what is his name? What is your
KP Barasaji.
Then? You can't use abbreviations here.
Lordship, we need some time just to research, so just
Which
to get
one?
some kind of judgment.
But this is regarding that.
It was hard many times, but...
It's 10.
10.
Why you want adjournment?
No, court has asked last date to find out some
Authorities, my lord.
applicable to the facts of the case. So we are trying to find out.
Even remotely applicable, so you bring.
Yes, so remotely applicable, so that's what I am trying to find out.
But we'll also do
1 week.
more research
1 week
on
time.
it.
Yes, 1 week time to enable the matters. Matter remains part heard. The parties are allowed 1 week's time to the authorities, yes, on this after 1 week, yes.
All right, my lord.
Lordship, item number 15 to 20. This case, I can take the concern of SP Mohanta. I am not ready, Lordship,
Consent
this
is
case.
not, no more adjournment.
Today also he has gone to Nigri for treatment. I need also to prepare the case. The issue will be only one issue regarding Section 185 of the Contempt Act, whether the court, they can regularize it. That is the only issue court has framed. Two issues, in fact, the court has framed. Where the appeal lies. Appeal I have not filed because I thought that it can be regularized under Section 185. So that is only one issue.
How many? 1 day adjournment?
10 days,
Tomorrow?
Lordship, only 10 days I need.
It's been adjourned too often.
Only about 10 days, Lordship. I'll come on the next
There's only 16 matter, I think, in this court.
by this month only. After 10 days.
After 1 week, yes.
Okay.
Else we'll take it up without the lawyers being there also, yes. Yes.
May I please, Your Lordship? I beg to mention item number 29, Your Lordship. I pray for 1 week time, Your Lordship.
Why? Where's Mr. Singhan?
On his way, Your Lordship.
I will hear his contempt. We will take it to logical conclusion. Leave this contempt because there's some materials here.
Lordship, I also want
After
to
1 week.
support the adjournment because I'm also not feeling okay.
We will take it to logical conclusion, yes. After 1 week.
Your Lordship,
On the
just
train.
want to ask 2 weeks time. I'll just go out so much.
Okay, 2 weeks time, yes.
Your Lordship, may I beg to list the unlisted matter, Your Lordship?
When tomorrow?
Mention the unlisted matter for tomorrow, Your Lordship.
What's the matter about?
Your Lordship, I was appointed as assistant teacher in a deficit school, Your
Is it
Lordship.
urgent?
Yes, Your Lordship. My appointment was about to scrap, Your Lordship.
Now?
Before Friday, Your Lordship.
Tomorrow is. Yes.
Please, Your Lordship, I beg to make a mention of item number 30.
Number?
30.
13?
30.
30.
I pray that 2 weeks' time may be allowed, Your Lordship.
Okay, 2 weeks as paid, yes.
Highly Your Lordship.
By the respondent.
Please, Your Lordship, I beg to make a mention of party of the hearing list, item note 25 and 26, Your Lordship. I have taken the concern of the others.
Why?
I'm not personal. I have some difficulty.
You're not feeling well?
I'm not so feeling well, Your Lordship.
Well enough to come to court, not well enough to argue. Yes. Okay. After 1 week.
Yes, Your Lordship.
Yes.
Supplementary list, item number 2.
What is this?
This is almost a mercy petition, my lord. My lord, the
Mercy petition?
but the commercial court, my lord, in the execution proceedings says, though we made a submission that the payment is under process, my lord. My lord, here what happened, my lord, this was the arbitration proceeding under the old act, my lord, 1940 act. And 2003, the award was passed, my lord.
2003 all was passed.
2003, my lord.
Now 20 years, I mean,
Now,
20 years passed, it's not been executed as yet.
but now, my lord, what happened under the old act, we filed a challenge under section 30 of the Arbitration Act before the assistant to deputy commissioner, my lord. And they also filed under section 14 and 17 to make a rule of the court, my lord. That remained pending for 15 years before the trial court, my lord. 2008.
15 years to make
15
rule of the
years
court,
before
the
trial
award.
court, my lord.
Then?
In 2018, my lord, there was a change in the council of the central government, my lord. And an ex parte order was passed making the award rule of the court, my lord, in 2018, my lord. Now, after 4 years, my lord, without department was totally unaware about that 2018 order, my lord. 2022, towards the end of 22, my lord, they filed an execution petition before the court. After coming to know about the order passed by the trial court, my lord, we filed an appeal before. Now, appeal is also pending before the same court, my lord, but in the capacity as deputy commissioner, my lord, because the appellate forum is deputy commissioner. Now, execution proceedings are pending before the commercial court, my lord. We made a submission, my lord. Let us deposit, give us some more time. We'll deposit the money. Please don't disburse the amount to the party, and the matter can be heard. Our appeal can be heard. If we succeed in the appeal, there is no point in carrying
What's
on.
the amount involved?
My lord, original award was 19 lakh rupees. With interest, it has become 2.5 crore rupees now, my lord.
19 lakhs.
My lord, it is with interest. Now, interest on interest has been awarded by the trial court, my lord. Which is
Fair
not,
enough, if the award was 1,003, put it on the shoes of the contractor.
my lord, but there are lapses on their part also, my lord. 15 years it was pending before the assistant to deputy commissioner,
Okay,
my
now
lord.
what
Now, my lord, the impugn order, lordship, kindly sees, my lord, last page 133, my lord.
$133,
3,
yes. 1324.
my lord.
Yes.
CR put up so and so. Union of India is represented by so and so. 3.5 months time was granted to the judgment debtor to satisfy the decree. However, even today, no such sanction could be placed by the judgment debtors to satisfy this court that the decree is likely to be satisfied anytime soon. In view thereof, this court is not inclined to grant further time to the judgment debtor. Execution shall proceeded with issue warrant of attachment believed to
Now, who's the
Chief Engineer MES, my lord.
who's the judgment debtor is whom?
Chief Engineer MES. My
So
lord,
they
locking
will do-
down the office of Chief Engineer, my lord, Chief Engineer caters to the entire Northeast in the defense establishment.
They'll attach the office.
My lord, that is the order, my lord. And to freeze the bank account also, my lord.
To?
Freeze the bank
Where
account.
the free bank account? Not here.
But it is not mentioned here, my lord, but the warrant which they placed, my lord, I'll just
Where's the
point out.
warrant?
Page 69, my lord. Though it has not been signed, but this is what they have filed before the court, my lord. Page 69.
Filed on?
This was filed at the time of filing of execution petition, my lord, in 22, my lord. At the bottom, my lord, execute the decree by attachment of bank account and sale of all movable, immovable property judgment debtor, including vehicle, so and so, so and so. Lord, we are in the process of payment, my lord. 1 month's time is granted by lordship, my lord. We'll deposit the amount in the court.
3.5 months' time was granted by the executing court also.
3.5 months was granted, my lord.
It's long enough for action to be taken by the MES.
My lord, what happened, my lord? The sanctioning authority is the Ministry of Defence, my lord. The file has already reached Ministry of Defence, my lord. Some accommodation is given to us, my lord. We will deposit the amount in the court, my lord.
You'll come by 227.
My lord.
It's order 21.
Order 21. My lord, Order 21, Rule 26 also, my lord, provides for similar circumstances, my lord.
That's executing court only, not before the, not an application of 22. Yes. This is for the executive court only.
This is for the execution court only.
Yes.
That's why we have come under 227. My lord. My lord, our only concern, my lord, the office is attached, bank accounts are frozen, my lord. The entire functioning of the chief engineer's office will be affected. And they are defense establishments.
You can satisfy the decree in 2 weeks' time.
My lord, if the matter is posted after 2 weeks, my lord, we will make all endeavors and probably will be able to deposit the amount by then, my lord.
I will issue notice to the
My lord.
respondent also. Yes, heard Dr. Enmo's color, DHGI. So and so. Stop, issue notice to the, is a sole respondent?
Sole respondent.
Sole respondent, steps were taken within 2 days. Stop. Next paragraph. It has been submitted by the Senior Counsel that that the limited grievance, not that the grievance of the petitioner before this court in this application of 227 is with the order of attachment dated
1/3/24.
1/3/2024 passed by the Commercial Executing Court bracket Commercial Court Shillong in
Commercial Arbitration
Execution case number 8 of 2022. Stop. It has been submitted that steps have been taken to satisfy the decree, but however, due to what procedural requirements, the same has not been satisfied till date. Stop. It's further submitted that by the impugned order dated 1/3/2024, an order has been issued for attachment of the office of the
Office and bank account.
office and bank accounts of the garrison engineer,
Chief engineer, MES Ceylon.
at MES Shillong. Stop. The Senior Counsel submits that if the order is carried out, it will result in dislocation of the entire activities of the MES, which has a large jurisdiction. If it is that in the interim, at least to the next date, that the interim order be stayed. Stop. Considering the fact of the case of let the matter appear after 2 weeks, the interim order shall remain suspended until next date.
Deeply.
Item number 3.
Yes.
Lordship, as per earlier order, your Lordship was pleased to grant time to seek instruction. So my
Sir,
instruction is that to
Go to Tupra.
withdraw.
Yes.
No, Kohima, Lordship.
Kohima or Tupra?
Kohima
You've
bench.
gone to Manipur.
No.
Now you've gone to Kohima.
Yes.
Now you come to Shillong.
Yes.
Now go to Agartala.
No,
Why?
because Lordship,
See, the officer there is from Agartala.
No, Your Lordship. Because, Lordship, I have filed a writ petition at Kohima bench, Lordship. So
You filed Manipur also.
that is a separate issue, Lordship. I have.
Yes. Mr. Bitep, please will have to withdraw the application and to prefer the same before the jurisdictional High Court. Yes. The honest matter stands goes and disposed of.
Item number 4.
May it please Your Lordship. Your Lordship, here the respondent authority has issued an advertisement dated 28/6/2023 inviting tenders from the eligible citizens for appointment of retail outlet dealerships in the state of Meghalaya with the closing date on 17/10/2023. Your Lordship, pursuant to the said advertisement, petitioner here has submitted her application along with the requisite...
Retail outlet means petrol pump.
For petrol pump.
Okay, yes.
Then she has submitted the application forms and participated in the tender process. She has submitted her application form on the 23/9/2023. And Your Lordship, in this regard, the entire communications and correspondence has been through online process. So on the 16/12/2023, the petitioner received an email from the respondent authority. That is at page 19, Your Lordship.
Okay.
Page 19. Informing the petitioner that she has been qualified for draw of lots for selection of the retail outlet dealership. And the petitioner...
What does it say? Please refer to so-and-so. You have qualified for... Okay. Yes, then what happened?
You have qualified for draw of lots for selection of RO dealership. You are requested to be present personally along with photo identity card issued by any government department on so-and-so at the following address. So accordingly, the petitioner has appeared for the drawing of lots. And thereafter, Your Lordship, on the 28/12/2023, the petitioner came to learn that her name has been selected at the draw which was held on the 28/12/2023 through the online portal. And the respondent authority's white email dated 29/12/2023, which is at page 22, Your Lordship,
Yes.
has intimated the petitioner
Okay.
at page 23, Your Lordship,
Yes, yes.
the respondent
But
has...
the intimation to the provisional selection. Okay.
You have
So
been
you were
declared
selected,
as
okay.
provisionally selected, Your Lordship. And thereafter, Your Lordship, the petitioner received another email on the same date, that is 29/12, intimating the petitioner to remit the initial security deposit of 20,000 rupees.
Then what happened?
Then accordingly, the petitioner has paid the security deposit also, Your Lordship. And after the payment of the deposit of the initial security deposit, Your Lordship, the petitioner has failed to receive any further correspondence from the...
After which date?
After 29/12/2023.
Okay.
Whereby the petitioner was requested to pay the
Yes.
the security deposit and also to upload her self-attested documents. Then, Your Lordship, the petitioner after that has failed to receive any more correspondences from the...
After 29 December?
After 29 December.
Okay, then what happened?
Then after that, Your Lordship, it was only on the 6th of February 2024 that it came to the notice of the petitioner that the respondent authority has sent an email dated 18/1/2024, which was not received by the petitioner, intimating
Where's
the petitioner, Your Lordship.
Not here.
No, Your Lordship, that email was not in the possession of the...
Okay. Then how do you learn about it?
Through the website, Your Lordship, portal.
What does it say in the portal?
Your Lordship, that
What is
there
the
has
case
been
about
some
now? He's been rejected?
discrepancy. Your Lordship,
Has
I will
your-
come. Yes, I will
Yeah,
come to
just-
that, Your
yes.
Lordship. Then that there was some discrepancy in the documents submitted by the petitioner, and the petitioner was directed to furnish the rectified documents.
Okay.
And then, Your Lordship, it was only on the 6th of February 2024.
Yes.
I have made a statement in my petition, Your Lordship, in Para 9, that it was only on the 6th of February 2024 that there is an email dated 18/1/2024. Sorry, Your Lordship, that email is at page 27, Your Lordship.
Yes.
18 Jan 2024. You are requested to upload the following rectified correct documents by 8 Feb 2024. And Your Lordship, here the petitioner has never received the email, maybe due to network error or some problem.
Okay.
Then after that, Your Lordship,
So your case, you didn't receive this communication, so you could not upload the rectified documents.
no, Your Lordship, actually
And
on the
then
6th,
the rectified documents, and so it's been rejected, your candidature.
Your Lordship, on the 6th, I have tried to upload the rectified.
This email is 18 Jan.
Yes.
Then on the 6th of February.
6th of February, I have tried to
What
upload.
time limit did they give you?
Pardon, Your Lordship?
Within how long would you supposed to upload it?
Within the 8th of January.
No,
8th of
18 January,
January.
they said.
Yes.
You could to by 8 Feb. Okay.
By 8.
Yeah, yes.
Then, Your Lordship, I have tried. I have tried to upload my the rectified documents, the affidavits, on the 6th of the Feb itself. However, Your Lordship, there was no option available in the portal to upload the rectified documents. As a result of which, Your Lordship, I have uploaded the already scanned documents, means the previous uploaded documents.
For you, there's no scope for reloading.
There is no option,
How is that
no
possible?
link. I'm
Yes, then what do you want now?
Then, Your Lordship, on the 19, Your Lordship, 19/2/2024, I have approached personally the office of the respondent authority
Yes.
with a prayer to allow me to submit the rectified documents.
Okay.
Then, Your Lordship, the respondents has informed me that an email would be sent to me and to comply with it accordingly. Then, Your Lordship, to my shock and surprise, Your Lordship, I have received one email, one communication dated 23/2/2024,
Yes.
which is at page
What does it say?
35.
Yes.
Your Lordship,
Rejection
why
is-
this email?
Okay, in view of the above regarding can be found eligible, however, can you make a considered selection? What do you mean around group 3 applicants as per guidelines? So you want reconsideration? Have they already settled it with someone else?
Your Lordship, and they have also, if I have any grievance to submit my
Okay, that's fine.
representation.
But then, like, have they already given it to someone else?
No, Your Lordship. But there
Yes,
is an
Dr. Mosika.
anticipation, Your Lordship,
So
that they
you
might.
filed you filed representation. That means you have filed it.
Yes, I filed on
That
the
was result of
27th.
that.
Your Lordship, till date to.
Yes, Dr. Mosika.
My lord, I represent only Union of India. Bharat Petroleum is the
Yes.
main contested respondent.
How do you could dispose it of? Because there's only, it seems like it's a technical glitch only.
Very minor
UPCL has to be
discrepancy, Your Lordship.
Who's appearing for? Oh no, on this Indian oil. Yes.
Please, Lordship.
Yes.
Please, Lordship. Lordship, I believe one of the respondents is Bharat Petroleum.
Yes.
Lordship, if Lordship kindly allows this matter to come up tomorrow, I'll take instructions from them, my Lord.
See, it's only a
Tomorrow,
matter
yeah.
of a technical glitch in the sense that you cannot upload the documents on time.
Understood.
Because
Understood.
in Garo Hills, you understand how situation is also. And
Understood,
so if
my
the
lord.
representation, you address it right, we'll leave it there tomorrow. Take down heard so-and-so issued note, not issued notice. Add that Dr. N. Mozika is present on behalf of the respondent number.
1.
Heard so-and-so, Dr. Number 1, stop during the course of the matter, Mr. S. Jindal, who is present virtually, has submitted that create the matter that he has instructions to appear on behalf of the respondents 2 and 3. He prays the matter be listed tomorrow. Yes. List the matter tomorrow, motion columnist.
In the meantime, Your Lordship, there should be no...
One day.
Item number
Meantime,
5.
you mean tonight, let's settle with someone else.
They may issue advertisement for fresh tender.
Item number 5.
Yes.
Your Lordship, the counsel will be appearing through VC. Your Lordship. Lordship, the conductor.
Yes, who's the for the petitioner?
Mr. AG will be there.
I can't see anyone. Where's the petitioner?
I am for the respondent, of course, my lord.
Yes,
I am appearing for petitioner, my lord. Am I audible, my lord?
Audible but not visible. Okay, yes. Yes.
I am visible also, my lord?
Yes.
Yes. Your Lordship, the order before Your Lordship is the order of District Judge, Commercial Court, upholding or dismissing my objection as to the maintainability of petition under section 29A before District Judge, my lord.
29A?
29A. My lord, let me briefly recapitulate the facts. My lord, the application was filed by the respondent under section 29A for extension of mandate of the arbitrator, my lord.
Okay.
Before learned district judge.
Okay. What happened?
The contention of the petitioner before Your Lordship is that the learned district judge has no power under section 29A to extend the mandate as it involves appointment of arbitrator in case of substitution of arbitrator.
That's your contention?
That's my contention, because that contention is based on the premise, my lord, that the on the premise that the appointment power of is specified in section 11.
Okay.
And that power can be exercised only by the High Court. Now kindly see in this light, my lord, kindly see the impugn order, my lord, my contention which have been noted, and straight away, Lordship, kindly see the impugn order at page 32, my lord. Page 32 order starts, my lord.
Yes.
Now page 32, after noting down my objections, my lord, the definition and judgments which I have cited are page 34, my lord. Second, my objection, sir. And paragraph 2 records my objection, my lord. Kindly permit me to read this. Sri S. Pandey, appearing for Chief Engineer, submits that applicant by this application under Section 11 of Commercial Code Act, read with 711 of CPC, is raising jurisdictional objection to the maintainability of commercial arbitration case of Arbitration Conciliation Act. Instant application filed by respondent herein 29A subsection 4 of Arbitration and Conciliation Act is not maintainable, is in as much as court has no jurisdiction to entertain the application for extension of mandate under Section 29 capital A of Arbitration Act. London's counsel submits that commercial code has no jurisdiction to entertain application since power of extension of mandate is concomitant with the power of appointment of arbitrator. Section 29A(6) of Arbitration Act provides that court, while extending the mandate, can substitute one or all arbitrator. London's counsel submits that such a power of substitution is inextricably connected with power of appointment of arbitrator, which is only available with High Court under Section 11 of Arbitration Act. In the present case context, the expression court used in 29A of Arbitration Act does not mean principal civil court of a district in a district under Section 2E. Section 2 is preceded with the expression unless the context otherwise requires, which means court would mean principal civil court in a district court only if context does not indicate otherwise. Subsection 6 of Section 29 of Arbitration Act indicates that expression used in Section 29 of Arbitration Act indicate that court means High Court, as the power of appointment of arbitrator is only with the Honorable High Court in the context of domestic arbitration. Learned counsel submits that Honorable High Court of various states have consistently held that only High Court has jurisdiction to retain under the application of extension mandated under 29 of Arbitration Act and relied upon, my lord. These are the judgments which have been referred and relied upon, my lord. Now, the argument of the other side is, my lord, based on that the High Court is not having original jurisdiction And therefore, if the High Court is not having original jurisdiction, the application will lie to the district judge. That was the objection. My case is not that it's a case of original jurisdiction or not. My case is, my lord, that under 29A, and I just one more paragraph, then thereafter I will take your lordship to the relevant, the paragraph 9, my lord, at page 38.
Yes.
The judgments which have been relied on by the respondent, my lord, and at the foot of the page, if your lordship will see.
Page 38.
Page 38, paragraph 9, last two line, my lord, of page 38, paragraph 9.
Yes.
If your lordship will notice that Excanco Capital Services Limited versus State of UP versus so and so. In this case, my lord, the Allahabad High Court has relied upon a judgment of the Honorable Supreme Court in Nimit, my lord, a lordship on next page at 39, Nimit Resources versus so and so, to say that Prince relied upon by the... Yes, this is the judgment relied upon by the respondent, my lord. I am highlighting the judgment relied upon by the respondent.
No, please come slowly, Mr. Amir Kumar. You're going a bit too fast. Now your basic ground is that 29A is not maintainable before the principal district court. Correct?
Yes. Yes, sir.
It is preferred before the court of before the High Court, because by virtue of Section 11 of the Arbitration Act, which gives the power to the High Court to appoint an arbitrator. So you say that it's a continuation, so it's like a corollary to the Section 11, the 29A. But then what is the definition of court? Now, they've given here under Section 2E. Anyway.
Yes, my lord.
What does it say? Now, why you want to place judgment now?
I'm coming to that part, my lord. Yes. Section 2, interpretation of Section 22E.
Okay, no, you can't do this. Why are you reading just now? You can't read don't read out of context. Just read it where we can understand.
Yes, my lord. Yes, my lord.
I'm not as fast as you, so yes.
Your lordship, kindly come to the finding of the learned district. Para 19. Finding of the learned commercial code, my lord. Para 19.
Yes.
At page 44.
Yes. Yes.
The High Court of Meghalaya does not exercise ordinary original civil jurisdiction in respect of subject matter of arbitration in the state of Meghalaya. The argument advanced by the petitioner that the expression code used in Section 29, capital A of Arbitration Act does not mean principal civil code in a district under 2E is not in line with intention of legislature. Had the legislature intended to house the jurisdiction of principal civil code in the district under Section 29A, same would have been clarified in the statute itself, as has been done in Section 47, where the legislature has inserted an explanation clause. Thus, there is no ambiguity in the interpretation of code under Section 29, capital A. The interpretation of code in Section 29, capital A has to be made accordance with the intention of accordance with definition of code in Section 2E. In my consideration, it would mean principal civil code of original jurisdiction as defined in 2E, my lord. My contention before the learned district was, my lord, that the extension of mandate would also involve the substitution, possibly involve substitution of the arbitrator. And substitution would mean appointment, because a person can be substituted by way of appointment only, my lord. So therefore, once it comes to the issue of appointment, my lord, the power is vested with the High Court, my lord, and straight away, my lord, I take your lordship to the judgment of Delhi High Court, which has extensively discussed and dealt at page 79, my lord, on this issue, page 79 of the paper book, my lord.
79.
79, my lord.
Yes.
Paragraph 2, my lord.
Yes.
Paragraph, this is an application filed on behalf of petitioner under Section 151, CPC, seeking recall of order dated 31st July 2019.
No, but one second, Mr. RK General. The thing is that Delhi, Calcutta, Madras, Bombay, they have original jurisdiction.
Your lordship,
original jurisdiction, but here we are in a different footing.
No, my lord. Question is not of original civil jurisdiction. Question is of the appointment of arbitrator by the court under Section 11.
Okay, you carry on. Yes. What do you want to say by the judgment?
No, the point which I was trying to make, my lord, that
Yes.
the principal civil court or the principal civil court or court having original jurisdiction may not have the power to appoint the arbitrator under Section 11.
Okay.
Power to appoint the arbitrator emanates from Section 11, which power is vested with the High Court, whether it is having original jurisdiction or not having original jurisdiction, my lord.
Okay.
So kindly see this judgment, my lord, because there is a detailed discussion on this issue, my lord, and various judgment has been referred to in this judgment. The petitioner has filed present petition under Section 29A of the Arbitration and Conciliation Act, paragraph 3, I am reading, my lord.
Yes.
For extension of mandate of learned arbitrator, the court had issued notice to respondent. Respondent filed his reply and objected to the maintainability of the petition before this court on the ground of lack of pecuniary jurisdiction as the value of claim was less than 2 lakh rupees. So then in that case, High Court also, High Court is having original jurisdiction, but High Court was not having pecuniary jurisdiction, the objection was filed, my lord. When the matter was listed, the learned petitioner submitted that amount of claims and counterclaim in arbitration proceeding was below the pecuniary jurisdiction of the court and accordingly sought leave to withdraw with liberty to file the same before the petitioner was accordingly dismissed as withdrawn, granted the liberty sought. Present application seeks recall of the order of 31st, 2019. 6, my lord. Contention of learned counsel for the petitioner applicant is that power to extend mandate of an arbitrator under subsection 4 of 29A of Act beyond period of 3 months or further extend period in terms of subsection 3 rests with the court. Tribunal can extend the mandate by 6 months beyond the initial 12 months with the consent of the parties, but any further extension mandate can only by the court. Court has vast power of extension of the period even after such period is over, and while doing so, court can substitute one or all of the arbitrator as provided in section 29(6) and 29(7) of the Act. It is argued that reading the aforesaid provision, the inescapable conclusion is that term court in section 29 would be the High Court in case of domestic arbitration, which has exclusive power to appoint the arbitrator, and not the district court as per section 2(1)(e) of the Act. It is further argued that said interpretation finds force from the fact that it would be inconceivable that legislature would waste the power in the principal civil court to substitute an arbitrator who may have been appointed by Supreme Court or High Court. Even otherwise, it would be wholly impermissible, since power of the appointment of arbitrator when involved rests only in Supreme Court or the High Court, as the case may be, in terms of section 4, 5, and 6 of the section 11 of the Act. Hence, the civil court cannot be given the power to extend the mandate of arbitrator so appointed. Learned counsel, in order to substantiate this argument, submit that the power of extending mandate of an arbitrator also includes power to substitute the arbitrator. If in a given case and for valid reason, the court, while exercising the mandate of arbitrator, finds that it is so necessary, it can substitute the arbitrator in the same proceeding. Surely this power is only with the Supreme Court or High Court, given the nature of arbitration, and in case it is to be held that civil court can extend the mandate of arbitrator, then it would be required to be held that civil court, while extending the mandate, if so required, can also substitute the arbitrator. This would be clearly in teeth of provisions of section 11 of Act. A court which does not have the power to appoint an arbitrator can certainly not have the power either to substitute the arbitrator or even to extend the mandate of arbitrator under 29A of the Act, to say the least. Learned counsel submit that the conflict can be resolved by understanding the term court for the purpose of section 29 capital A as the Supreme Court or High Court exercising power under 11 of the Act, and any other interpretation would be contrary to entire scheme of the Act. It is also pointed out for fact several courts below have been rejecting application under section 29 capital A of the Act on this very ground, and only Supreme Court or High Court would have the power to extend the mandate of the arbitrator, as the power to appoint the arbitrator lies only with Supreme Court or High Court, as the case may be. On the merit of the case, my lord, after this, my lord, 13, my lord, paragraph 13, my lord.
That's the submissions of the petition. Yes.
Yes, my lord. And so, because submissions are somewhat similar before your lordship, my lord. That's why I went in detail in submissions, my lord. Paragraph 13. Respondent has objected to the present application on 2 grounds. Learned counsel argues that claim amount excluding interest cost is 17,79,000, and thus this court does not have pecuniary jurisdiction to entertain the present petition. He submits that learned counsel for petitioner has clearly admitted to the fact that had therefore withdrawn the petition with liberty to approach or competent. It is not open to petitioner to seek recall of the order. This was the submission, my lord, and then your lordship will see the finding. And your lordship kindly keep in mind the fact that it is the High Court was not examining the issue that the High Court of Delhi is having original jurisdiction, my lord. High Court was examining the issue whether it has the power to appoint the arbitrator under Section 11. Yes. Now, my lord, kindly see page, paragraph 20 at page.
Even in this case, original jurisdiction is with High Court.
Yes, and your lordship, even in this case, original jurisdiction is with the trial court. Now, kindly see, my lord, paragraph 20. 21. The main controversy that arises for consideration in the present application is whether petition has filed earlier and subsequently withdrawn is at all maintainable in this court, or the power to extend the mandate of arbitrator lies with the civil court of original jurisdiction in terms of definition of the code in 2(1)(e) of the Act. In order to decide the said issue, it is important to take note of certain provisions of Arbitration and Conciliation Act 1996, which reads as under, my lord. The 2(e), my lord, court means in the case of an arbitration other than international commercial act, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of ordinary civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration if the same had been subject matter of suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes, my lord. So then civil court is there, my lord, 29A.
Yes.
The time limit for arbitral award. The parties may, by consent, extend the period as specified in subsection 1 for making award for a further period not exceeding 6 months. 4. If the award is not made within the period specified in subsection 1 or extended period specified in 3, the mandate of arbitrator shall terminate unless the court has either prior to or after the so specified extended the period. Yes, either unless the court has either prior to or after the expiry of the period, so specified extended the period. Yes, and my lord, here the issue is unless the court, which the court we are trying to interpret this word court in section 29. 4 million, provided while extending the period under subsection, if the court finds the proceeding have been delayed for the reasons attributable to arbitral tribunal, then it may order reduction of fee, but not exceeding 5% for each month of such delay. Extension of period under period referred to in subsection may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. My lord, 6 and 7. While extending the period referred to under subsection 4, it shall be open to the court to substitute one or all of the arbitrator. So then the important words in my humble submission is substitute one or all of the arbitrators. My lord, under section 11 of International, under section Arbitration Act, the arbitrators are appointed by the Honorable Supreme Court and also by this Honorable Court. Now those arbitrators will get, if the period is not completed within 20 specified in the section 29A, my lord, those arbitrators cannot be changed by the principal civil court or civil judge, my lord. While now 6, my lord, I'm sorry for
the second part.
Yes. If one or all the arbitrators are substituted, the arbitral proceedings shall continue from a stage already reached and on the basis of evidence and material already on record, and the arbitrator appointed in this section shall be
arbitrators appointed
under this section shall be deemed to have received the said evidence and material. So appointed, my lord, these words are of significance, my lord, and they
so
cannot.
you draw that that means it flows from 11. That means it can be
Yes,
read
my
as
lord,
11. The appointment
is
also is there in 29A6.
Yes, my lord, I bow down, my lord, I am highly obliged, my lord. What I say, my lord, that your lordship your lordship under section 11 has been appointing the arbitrator, my lord. And period and the mandate has to be extended by principal civil court.
Suppose the arbitrator is appointed by Supreme Court. What happens then?
So therefore, this was the logic.
Suppose an appeal for the Supreme Court and the 29A situation arises.
And your lordship kindly see 7 also, 29(7) also, 29(7) also. May not kindly see 29(7).
Suppose this Arbitrator General, the Supreme Court is appointed in international arbitration, is appointed an arbitrator, correct?
Yes.
Now, can
Yes,
they
sir.
go to civil court to get the extension of the arbitral tribunal of the limit for the extend the limit for the award?
No, therefore, that for this reason only, the court which has the power to appoint will have the power to extend it, my lord. Because
but the thing is that means this law needs further amendments.
Your Lordship, kindly see, this further has been discussed in detail with reference to various judgment also, and I have a recent judgment. Kindly see 29(7), my lord. In the event of arbitrator being appointed under this section, my lord, the arbitral tribunal thus reconsidered shall be deemed to be in continuation of previous. So the entire idea or the aspect of the scheme of the act, my lord, envisages that when it comes to the appointment, it has to be exercised by Honorable High Court or Honorable Supreme Court in the facts and situation of the case, my lord. Now, 22, my lord. Section 11, 5 and 6 of the Act relates to the appointment of arbitrator by High Court or Supreme Court, as the case may be, and details the procedure to do so therein. In case of international commerce, the power of appointment is vested only with Supreme Court, while in other arbitration, court has the power to make appointment in terms of Section 5 or 6. Section 29 came to be inserted in the statute by amending Section 3 of with effect from 23/10/2015. My lord, kindly mark this amendment date, my lord, because the trial court has relied upon a judgment which is prior to the amendment of Section 29A, the judgment of the Honorable Supreme Court in Nemeth case, my lord. In that case, my lord, the judgment was not considering the scope and ambit of Section 29A, and trial court has relied on that judgment to say that power to appoint is vested with civil court, my lord. 23, my lord, kindly see. This section has been extracted above. Perusal of this section indicates that it provides for. I was reading section paragraph 23, my lord, at page 86.
Yes.
Section 29, capital A, came to be inserted in the statute by amending Act 3 of 2016 with effect from 23rd October 2015. This section has been extracted above. Perusal of this section indicates that it provides for timeline within which the award has to be made, including the timeline up to which the tribunal can extend the mandate with the consent of parties. The power of the court to extend the mandate has no timelines, as is clear from the reading of the relevant provision. One of the important provisions of this section is the power of the court to substitute one or all of the arbitrator while extending the mandate. Subsection 1 of Section 29A provides time limit of 12 months within which the award shall be made. Prior to the amendment of 2019, a starting point of 12 months was the date when the arbitral tribunal entered upon reference, but post 2019 amendment, the commencement date when the pleading before the arbitral tribunal is completed. Subsection 3 enables the arbitral tribunal to extend the period of 12 months by further period of 6 months with the consent of parties. Subsection 4 of 29A provides that award is not met within the statutory period of 12 months or the extended period of subsection 3, the mandate of shall terminate unless court either prior thereto or after expiry of period extend the mandate. The extension of course would be granted on application by any of the parties, but only for sufficient cause and on such terms and conditions as may be imposed by the court, and this is to stipulated in subsection 529. Section 29 of the Act incorporates an important provision by way of subsection 6, and which in my opinion is relevant for deciding the controversy in the present case. The provision confers on the court a significant power of substituting one or all of the arbitrator while extending the mandate under subsection 4 if the need arises in case any such substitution is made by the court. The arbitral proceedings shall continue from the stage already reached and on the basis of evidence or material already collected. Therefore, when it comes to the time limits for passing the award or extension of mandate, this section is a complete code in itself. When one looks at definition of term court under section 21(1)(e) of the Act, it is clear that in case of international commercial arbitration, court would mean the High Court in exercise of ordinary civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration if the same has been subject matter of the suit, or the High Court having jurisdiction to hear the appeals of courts subordinate to the High Court. However, in case of arbitration other than international commercial, court would be principal civil court of original jurisdiction in a district and includes High Court in exercise of ordinary civil jurisdiction, having jurisdiction to decide question forming subject matter of arbitration. If the same had been subject matter of this suit, the definition has been substituted by way of Amendment Act 3 of 2016, which came into effect. If the 27, my lord, is very important. If the definition of the term court is looked into, no doubt contention of the respondent seems plausible that power to extend the mandate of arbitrator would lie with the principal civil court. However, on careful analysis, in my opinion, this interpretation would lead to complication and would perhaps be in the teeth of powers of the court under Section 11 of the Act. Thus, the question that poses a challenge is whether term court can be interpreted differently in the context of Section 29, capital A. In my view, subsection 1 of Section 2 of the Act itself gives the answer, as it begins with the expression in this part unless context otherwise requires. Power to extend the mandate of an arbitrator under 29A for beyond the period of 12 months and further extend period of 6 months only lies with the court. This power can be exercised either before the period has expired and even after the period is over. Neither the arbitrator can grant this extension nor the parties by their mutual consent extend the period beyond 18 months. Till this point, interpreting the court to mean the principal civil court as defined in section would to my mind pose no difficulty. The complexity, however, arises by virtue of the power of the court to substitute the arbitrator while extending the mandate, and this complication is of a higher degree if earlier arbitrator has been appointed by High Court or Supreme Court. Coupled with this, one cannot lose sight of the fact that legislature in its wisdom has conferred the power of appointment of arbitrator only on the High Court or Supreme Court, depending on the nature of arbitration as and when the power is invoked by either of the parties. There may be cases in which while extending the mandate of arbitrator, the court may be of the view, for some valid reasons, that arbitrators are required to be substituted, in which case the court may exercise the power and appoint a substituted arbitrator and extend the mandate. In case a petition under Section 29A of the Act is filed before the Principal Civil Court for extension of mandate and the occasion for substitution arises, that Principal Civil Court will be called upon to exercise the power of substituting the arbitrator. In a given case, the arbitrator being substituted could be arbitrator who had been appointed by Supreme Court or High Court. This would lead to a situation where conflict would arise between the power of Superior Court to appoint arbitrator under Section 11 of the Act and those of Civil Court to substitute those arbitrators under Section 29A of the Act. This would be clearly in teeth of provision Section 11 of the Act, which confers power of appointment of arbitrator only on the High Court and Supreme Court, as the case may be. The only way, therefore, conflict can be resolved or reconciled, in my opinion, will be interpreting the term court in the context of Section 29, capital A of the Act to be court, which has the power to appoint an arbitrator under Section 11 of the Act. Accepting the contention of the respondent would lead to inconceivable and impermissible situation where, particularly in case of court-appointed arbitrator, where the civil court would substitute and appoint arbitrator while extending the mandate under 29A. Similarly, in case of international arbitration, if one was to follow the definition of court under Section 2(1)(e) and apply the same in strict sense, then it would be the High Court exercising original or appellate jurisdiction, which would have the power to extend the mandate and substitute the arbitrator. In such a situation, the High Court would be substituting an arbitrator appointed by Supreme Court, which would be perhaps lead to the High Court overstepping its jurisdiction, as the power to appoint the arbitrator is exclusively in the domain of Supreme Court. Thus, in the opinion of this court, an application under Section 29, capital A of the Act, seeking extension of the mandate of arbitrator would lie only before the court, which has the power to appoint arbitrator under Section 11 of the Act, not with the civil court. The interpretation given by learned counsel by the respondent that for the purpose of 29 capital A court would mean in the case of domestic arbitration would nullify the power of superior court under Section 11 of the Act. Perhaps Section 11 of the Act are filed irrespective of the pecuniary jurisdiction of the court, and same analogy would apply to petition under Section 29 of the Act. There is thus no merit in the contention of the learned counsel of the respondent that the court has no pecuniary jurisdiction to entertain petition at the value of the claim below 2 crore. In my I am 45. So this is the rationale.
Yeah.
And
the simple rationale that is a part of the High Court. How can the low court?
Yes, my lord. There is one. If your lordship will see, this judgment was cited before the learned district judge, and despite placing all these, my lord, the learned district judge has not even referred to these paragraphs and relied on the judgment, which is not even under 29A, my lord. One more aspect, my lordship, kindly see Section 14 for Section 14, my lord, of Arbitration and Conciliation Act, which also talks about substitution, my lord. Because there is a recent judgment at termination, and in case of termination, my lord, who will have the power to appoint, my lord? That issue also recently came before the Honorable Supreme Court, my lord, in 2022, 10 SEC 235, my lord. So,
Yes.
Section 14, my lord.
Yes.
Failure or impossibility to act. The mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator, my lord. So, your lordship, kindly see here also, in case of section 12 and 13, those are the challenges to the appointment of arbitrator, my lord. Procedure is in 13, my lord. And in case of challenge is laid and the application is moved, the arbitrator is required to be substituted under section 14 below.
On these two counts.
On these two counts, one count is that he becomes de jure or de facto unable to perform his function, or for other reasons failed to act without undue delay, and he withdraws from his office or parties agrees to termination of his mandate, my lord. So this issue, my lord, came before the Honorable Supreme Court. Two, my lord. If a controversy remains, my lord, citation is 2022 10 SEC 235, my lord.
Justice Margaret.
Justice Emerson. 2022 10 SEC 235, my lord. I have my colleague is having the copy, my lord. My lord, before I take your lordship to this judgment, my lord, in this case the application was moved before the Principal Civil Court for termination of the mandate of arbitrator, my lord, under section 14, my lord. And then the Honorable Supreme Court, my lord, in last paragraph, held that so far as termination of mandate is concerned, that application would lie with the Principal Civil Court of the district, my lord. So far as appointment is concerned, after the mandate is terminated, for appointment, if the parties do not agree for appointment of arbitrator, the application would lie to the High Court under section 11, my lord. Kindly see
One thing,
paragraph.
Mr. Arbitration, are you making final arguments in this matter today, or are you saving some other arguments for a future date?
Yeah, I am, your lordship, I can save my time, my lord.
No, I mean,
it requires some consideration, my lord. It requires some
consideration because the law is not clear at all. Yes.
Because there are some judgments from the High Courts taking some views, my lord. Those judgments have to be distinguished by me, my lord.
Yes.
Those judgments have been relied, my lord. So it will take some time, my lord. Those judgments have also been referred by a learned district judge. So I wish to place those judgments. If your lordship may have it on 11th or 12th, my lord, I will be physically present and I will place all the judgments also, my lord. 11th or 12th. Subject to your lordship convenience. Subject to your lordship convenience.
Lord.
Yes, Mr.
Yes, my lord, I am opposing, my lord, the Advocate General is correct. My lord, there are, my lord, other judgments, my lord, of, my lord. In fact, my lord, I think, my lord, we have more judgments, my lord, on this side than, my lord, there are judgments on the other side, which actually, my lord, explain section 29A with regard to, my lord, the jurisdiction. Because, my lord, in section 29A, my lord, if I can just make one submission, my lord, we'll find, my lord, that in section 11, my lord, the words High Court and Supreme Court are used. Yes. But in section 29A, my lord, it's the court.
Yes.
So it's really, my lord, the logic being, my lord, after appointment under section 11, my lord, the court really loses jurisdiction so far as, my lord, further appointment is concerned. It's under section 29A, which, my lord, also contemplates extension as well as, my lord, substitution. Otherwise, my lord, there are arbitration, my lord, where, my lord, will keep going back, my lord, with the section 29A, my lord, to the, my lord, High Court, my lord, with regard to, my lord, extension. And very important, my lord, my learned friend made, my lord, in the Delhi judgment, my lord, would have seen, my lord, that international commercial arbitration was mentioned, but 29A1 actually doesn't, my lord, apply to international commercial arbitration. Yes. We'll see one subsection 29A1 says so. There's only, my lord, it says, the proviso says, as expeditiously as possible, preferably within 1 year. So, my lord, there's no question of any extension there. So, my lord, I'm quite happy, my lord, if the learned Advocate General, my lord, wants to argue today, or whatever is convenient for my lord, I'm, my lord, ready to argue on this issue, my lord, whenever, my lord, it's convenient. I'll show, my lord, perhaps, my lord, the law, my lord, is on our side.
Yeah, no, we need this needs further consideration because the law is not clear at all. I mean, because court, we have to go delve into that. What is meant by court, and whether
yes, and similar issues will be coming before this honourable court time to time, my lord. So this issue has to be settled authoritatively, my lord.
When we come on more authorities, that's why this court was asking whether in the matter it has commercial arbitration, suppose the arbitrators have been appointed with Supreme Court, will the principal civil court or the Delhi High Court have the power? Well, they don't want to transgress on those kind of powers. You know, that's the thing. Yes.
Yes, madam.
29A1, Malad looks at Malad 29A1.
Yes.
Kindly Malad look at 29A1.
Yes.
And there Malad will find Malad the first opening section itself. The award in matters other than international commercial arbitration shall be made by the arbitrator.
Okay. Okay. That makes a distinction. Right?
Yes.
So we can't
so
take shelter of that.
But so far
So
as
they
the
can't take
appointment of
shelter of that.
arbitrator is concerned, Milord.
Correct.
So far as the appointment of arbitrator by the High Court is concerned, Milord, that is also because
Milord, it's a question.
Practically may not apply to international arbitration.
Right. That's fine. That's good. That was only a doubt in the mind of the court. Yes.
Milord, my submission is, Milord, that the question of Milord, principal civil court, Milord, court is only defined, Milord, once in 21E. So the principal civil court, Milord, is in relation to 29A, because that also deals with the function of Milord, extending time. Otherwise, Milord, for all extension of time, Milord, and all arbitrations, you will have to keep running back, Milord, to the High Court or Milord, to the Honorable Supreme Court, if Milord, the other side's argument has to be taken, Milord, as correct. Now, this is, Milord, something which Milord has to consider. I'm not saying, Milord, and Milord, we have several judgments. Milord, we can also, Milord, what we can do is, Milord, we can give Milord a
Can you
list
calculate compilation before the next date?
Yes.
We'll have it on 13th is fine?
Yes, Milord.
13th is, Milord, better, Milord, 11th.
In midweek, yes.
Yes. 13th, Milord, in the morning, Milord, if it's convenient to my Lord.
Yeah, 13th, we'll have to admission hearing, yes.
Well,
it appears that the matter requires further consideration. At least the matter of admission hearing on 13th March 2024. Yes.
And Milord, we'll submit, Milord, kindly give us leave, Milord, to give our compilation, Milord, before
Yes,
that.
parties are at liberty to,
And we will also
furnish
submit
the authorities before the next date, yes. Interesting, very
I'm very
interesting.
grateful. Very interesting, Milord. I'm very grateful, Milord. It's a pleasure, Milord. It's a pleasure, Milord, to see the learned Advocate General, Milord.
Item number 6.
Thank you. Yes.
I'm grateful.
Yes.
Item number 6.
Dr. Mozika. Where's the petitioner?
And for the petition. If they are willing to appoint a retired engineer in a time-bound manner.
Give the name.
But the list, anyone from the list. Number 1 can also be appointed.
Number 1? What's the list? What is it? Where's Mr. Nombri?
Serial number 2 we had requested.
Where's the list?
From the list.
That you give that day?
I'll give a fresh one.
Oh, yes, this one. Akhilesh Kumar.
This is serial number 2. We had
Number 2, Saurabh Mathur.
Yes.
Fine, Mr. Nombri, Saurabh Mathur.
Milord. MES, Milord, so it's
Joint Director. So what's this designation? Director General.
Director General. Joint Director General, Milord.
He's retired.
Retired, Milord.
All are retired, Milord.
Yes.
Number 1.
The panel of.
Number 1 could be appointed.
Let them be in number 2 because they prefer to avoid any further since arbitration day it seems today.
Because this is from MES, Milord.
Why if MES is the interested party?
CPWD could be appointed.
Number 1.
If they are okay with that.
I will appoint retired High Court judge then.
But number 2.
Number 2. There's a cost factor.
Yes, so that's why if we don't agree, we'll appoint a retired High Court judge.
This, my lord, the maximum fee payable is 5 lakh. And the department told me that one of the matters of a retired High Court judge, he charged 50 lakh.
The fees? Very reasonable. Okay, yes, our party's constitution of a panel of arbitrators, which has been supplied by the learned DSGI staff. In consideration thereof, the parties in agreement that the Shri Saurabh Mathur, retired Joint Director General MES, appearing seal number 2 of the panel, may be appointed as the arbitrator, ordered accordingly. Yes. Matter stands disposal. Otherwise, you should send it to many are there available.
Item number 7.
They wanted Justice B.K. Sharma also, yes. Yes.
This Lordship, this matter on that day only have submitted a copy.
Very good.
Complete.
We're still on motion? Yes. Huh? What's the matter about?
This is regarding the non-regularization, non-payment of the pension.
When did he join service?
He joined in service in 1995. My lord, this is the annexure.
95. Did you take notice, Mr. Khan?
Yes.
Mr. Pitamba heard so issue notice, Mr. Khan, the government advocates present on behalf of respondent 125. No further notice required. What about number 6? Where's Pasa? He's not here. Yes, E.B. Pasa is present except on behalf of number 6. So it's a matter of 3 weeks for instruction affidavit. You supply copy, Mr. Peter, supply copy to the signing counsel for respondent number 6.
Most pleased, Lordship.
Item number 8.
May it please your Lordships. My lord, this is that Weighbridge matter, my lord. The pleadings are complete, your Lordships.
It's post for hearing.
My lord, Lordship, my lord, the impression was given that it will be taken up for hearing today. In fact, it was there in the list today, yesterday. On the request of the other side, my lord, matter has been posted today.
After some time? You can finish today?
Yes, yes, I can finish. It's not very long facts. I'm just...
My learned friend can finish today, my lord, because I have one matter before the court number 1 also, my lord. So
he's there.
Even, my lord, I have one matter, my lord, number 3.
We'll see when it's called out.
My lord.
Maybe at times the matter is evaporated also there in court number 1, you don't know.
My lord.
Yes.
Daily list item number 1.
May it please your Lordship. Apart from respondent number 5, others have not filed affidavits, Lordship.
Why? Where's Sino Cloud? Who was Mr. Ganta was here?
He was here, he was outside.
Are they required to file affidavit? You're appealing for whom?
I'm appearing on behalf of respondent number 6.
Number 6 is?
CM of Khairem.
You are pro forma?
Yes, Lordship.
You're not filing, you are filing affidavit?
We are ready with the affidavit, but we are ready with the affidavit, but we just need the dependent signature. Only left with the dependent signature.
What about you appealing for whom, Mr. Nombri?
My lord, I'm appearing for number 5. I filed my affidavit.
And what about the council?
The council.
Council have made a statement.
Only filing, okay. MS, what's your name?
B. Ding Dong.
B. Ding Dong.
Sir.
MS B. Ding Dong, Learned Council of 6 praise for loud. We give you 1 week's time to file affidavit. Just thereafter. Any urgency?
No, Lordship. Let interim order continue, Lordship.
Interim order of any shall continue the next date.
Obliged.
Item number 2.
My lord, whether we be posted for hearing, my lord. Exchange of pleading is completed.
You file a rejoinder?
My lord, we have gone through the affidavit. It is not required for filing rejoinder.
So, Mr. Council submits that rejoinder will not be required in the incident matter. We praise the matter of the hearing. Not touched by the parties. This matter for hearing.
After 2 weeks, my lord.
After 2 weeks, yes.
All right.
3.
May it please your Lordship. Lordship, I am praying for 3 weeks' time to file our rejoinder.
How many times you prayed?
This is the first time.
First time. The Council Parisha prays for you. M.U. Ahmed?
M.U. Ahmed.
Yes, prays for and allowed further 2 weeks' time for rejoinder. Just thereafter. So,
Highly obliged.
Item number 4.
Forwarded his name for regularization to the government. We're waiting for clarifications, not approval.
no affidavit.
Lordship, his name has been forwarded to the government, so clarification is awaited, my lord.
Yes, and what about E.B. Pasa? Yes, MS NG Shilal, Senior Government Advocate, submits that from instructions, submits that on instructions received, the petitioner's name has been sent for regularization.
Yes, Lordship, and we are awaiting clarification,
And,
Lordship.
and As such, the waiting clarifications is the same. Will this matter after?
2 weeks, Lordship.
2 weeks is
Multiply, Lordship.
for the orders.
5.
May it please your lordship.
Affidavit file.
My lord, the affidavit is ready. We'll file it during the course of the day, my lord, for 1 and 2.
3, 4, 5 been served.
We have already filed our affidavit for 3, 4,
Okay,
and 5, Lordship.
Mr. S. Jindal, counsel for the respondent number 1 and 2, submits that affidavit will be filed in the course of the day. Ms. M. Rahman. Also, sorry. Service affidavit has also been filed on behalf of the respondents, indicating service respondents number 3, 4, and 5. They've all been served.
Your Lordship.
Such service complete. This is a matter of 2 weeks. For the orders and for appearance of the response 3 and 5 for the orders. Yes.
Lordship.
They've been served. Correct. I'm not checking the affidavit.
Yes, sir, Lordship.
Item number 6.
Yes, it's already on board.
On board?
Yes.
Lordship, we filed the affidavit, my lord.
Yes, what's the affidavit say?
Your Lordship, we have just received the affidavit yesterday, Your Lordship, so we need time to examine, Your Lordship.
You want to file rejoinder?
Yes, Your Lordship.
Yes. Who are you?
Respondent number 5.
Who's number 5?
Person claiming the veterinary benefits for.
Oh, it's between 2 wives.
The second wife.
You're paying second wife. Okay. Why are you taking so much time?
Your Lordship, there are certain documents that are very vital for the affidavit, Your Lordship. We have applied for the certified copy, Your Lordship, but we're still waiting.
What's your name?
A. Kharsom, Your Lordship.
Oh, yeah, okay. You were there last time also.
Yes,
Let's say some praise to council number 5. Praise for some further 2 weeks time of affidavit. The affidavit on behalf of the state respondents is already on board. It's a matter of 2 weeks for affidavit by number 5 years.
Much obliged, Lordship.
I'll oblige.
7.
My lord, the respondents are yet to file affidavit, my lord.
Respondent 3 and 4. I'm from respondent 4, Your Lordship.
Why haven't you filed, Mr.
On
Walla?
the next date, Your Lordship.
No, very bad.
Appearing on behalf of respondent 3, I'm praying for further 2 weeks' time, Your Lordship.
Why? What's the matter about?
Creation of a village, my lord. Relating to
Village has already been created, if I'm not mistaken.
It is not.
Then why did you put an affidavit, say the affidavit has already been created, the village has already been created and the case should be dismissed? We don't need any instructions.
I mean, they agree with the creation of the new villages. That's all.
Who are you?
I'm from the...
You're a creator?
No, I'm from the parent village. Yes.
Creator of the villages? Yes. And as from town?
I'm appearing on behalf of CM of Nongklao, CMshire.
Okay. 1 week's time?
Respondent 3.
1 week for the time as paid by the respondent number
4.
And your 5?
3.
3 and 4 granted. This after for affidavit. This after 1 week.
Obliged.
8.
Yes.
Please, Your Lordship.
If it's been filed.
The petitioner is supposed to file the affidavit against the application for impediment.
Lordship, in the meantime, government could have filed an affidavit so that the matter will be cleared. But here I need 1 week time to file my affidavit.
What affidavit do you need to file, Mr. Qureshi?
Because see, Lordship, when the matter is already decided by the division bench, a party coming again and...
Who's appearing for the other interested parties? What's that?
Mr.
May it please your Lordship. Lordship, in this matter, we have filed a miscase. That is, before my Lord today, miscase 24. That is for impediment in this matter. Writ petitioner, my Lord, is required to file a reply against that.
I need to a week time.
Let them make please so what?
No, Lord Ship. I need a 1 week time. Let me bring on records.
Why you objecting on pleadment? The more the merrier.
No, they are not the party in this case. They are not the party in this case.
They want to be a party.
They want to be a party, but
they
they
are
are
the
not
founders of the school, apparently.
But how the government can ignore? It is the government already said they are not the party. They have got no locus standi. In view of the judgment of the division bench, now government is supporting them. I don't know what way the government is supporting. For that reason, I need the government to file an affidavit.
No, let them file the affidavit, then we can file.
Yes, then I may 1 week time, Lordship. I may be given. I will file it.
Yes, Mr. General.
My lord, if they are seeking time, well and good, my lord.
Yes. Mr. Makurishi's praise email out further. In this case number 24, 2024 and WPC number 5, Mr. Makurishi and counsel respond for the opposite party with petitioner, right? Please email out 1 week's time, further time to file an objection to the implement application. Stop. Same not objected to by the other parties. Praise allowed. It's after 1 week.
State respondents will also file state respondents will also file an affidavit.
Naturally.
In the meantime, Your Lordship.
Yes, in the main case, state respondents directed to file the affidavit before the next date. Yes.
Lordship, there's an interim order, my lord, that may have to be extended, my lord.
Interim order?
Yes, the state, the school education officers taken over the administration of the school because their term has already expired, Your Lordship.
I came before tenures. I came before time. When the tenures expired, I appeared before this court and prayed for the stay orders. The court has directed in the meantime to district education officer to look into the affairs of the school.
Education officer should.
Oh, these articles will come subsequently.
Yes.
Mr. Jindal is a late entrant, you mean?
Yes, he wants to be as a party.
No, my lord, we were on caveat, my lord, we had filed a caveat.
No, he is not a party.
Okay, fine.
Item number 9.
Yes.
Please, Your Lordship. My Lord, the notices were issued but no response have come from either of the parties. And in the meantime, my Lord, my instructions are that the construction work has begun. So, unless Your Lordship protects me by way of some positive order, that the writ petition may itself be rendered infructuous.
Because it is Mr. behalf one, Mr. Kumar, present behalf of 228, so conference. No response, meaning notice has been served, all of them.
Notice has been served.
Appeared, correct?
Only as regards the private respondents are concerned, my Lord,
okay.
That may be awaiting because we took steps by registered post, but all other the official respondents, my Lord, that have been served.
What has been settled?
My Lord, I have been just assigned by the corporation to appear in this matter. I'll be able to file the affidavit positively within 1 week, my Lord. I have already been informed.
Where do you have any proof to show that the construction has commenced?
My Lord,
any photographs?
I can bring that if Your Lordship gives me some time, my Lord, I can bring it up before Your Lordship.
In the meantime, my Lord, we will also file our affidavit.
It began only day before yesterday.
Or otherwise, my Lord, let them file it, my Lord. Subsequent to will reply to the whatever documents he'll be producing before the school.
Settled.
My Lord.
Yes.
What has happened?
My Lord, now at this point of time, my Lord, I don't have any specific instruction with regard to what my senior counsel is responding. Only with regard to the counter affidavit, my Lord. My Lord, counter affidavit, my Lord, I have been informed that we will be able to file it in the next, before the next date, my Lord. However, with the new development, which the submission has been, I'm not aware of.
Okay, let's have it after 1 week.
My Lord, let them bring on record, my Lord. We'll reply to that also.
Your Lordship kindly makes an observation because otherwise, my Lord.
What are the observations? They are self-contact.
That, my Lord, my specific instructions are that the JCB machines have been placed.
We can't go on all submission, Mr. Datta, unless we have some concrete.
In that case, if Your Lordship takes it up next week, sometimes next week, my Lord, I can bring the photographs and I can submit an additional affidavit
13th,
to this.
after 1 week.
After?
On 13th.
On 13th, okay.
Well, in that case, I'll file a pursuit to that.
Affidavit. Yes, MS Arkoni.
Because this whatever submission I have to take instruction on that also. Or my Lord, an advance copy may be given to us. Therefore, we will be also taking instruction on that.
Yes, and she's anticipated 1 week time for affidavit. Stop. It has been submitted by Mr. The learned senior counsel that in spite of the orders of this court, construction has commenced. The contract been settled, construction has commenced. Stop.
2 to 8, my Lord.
He is permitted to bring any
Documents, my lord, photo
he's
proofs, my
able
lord.
to place facts to substantiate the submission.
Through additional affidavit.
Yes, by additional affidavit. Ms. Arconi,
2 to 8, my lord.
undertake to file to give advance copies of the affidavit to
My
the
lord.
petitioner, so as the petitioner of the additional affidavit to the respondent.
So on 13th, Your Lordship.
This is a matter on 13th. As a fixed matter.
11, your hearing, 11.
I'll come that side. Come this way.
My Lord, this with regard to the management of the school, the two schools, LP school and the UP school. The first WPC relates to the LP school. Now, my Lord, who is the owner or who is the sponsoring body? My Lord may not go into that aspect of the matter. And here the only
we traveled
issue.
quite far in this case. This case, he's retired.
That is
He
true.
still wants to be the sole sponsoring body. He wants to be the single man. How is that permissible?
Because the school was given to him.
That
School
will
was given to him.
suppose we don't say the school is given.
My Lord.
It started from building a village school.
My Lord.
Village said we can't look after it. Mr. Petitioner look after it. So he ran the school for Humphreys 86.
My Lord, in more than 40 years.
More 40 he ran the school. He did whatever he liked. He this so on and so forth. He was he nominated the members so on, and then he retired. And then now they want the school back.
Now, in the handing over of 1980, there was no condition that the school will be returned back to the village authorities. Village unable to run it.
But you acknowledge that the school was established by the village, correct?
Well, that is true. We don't dispute. But village unable to run because of shortage of financial difficulties.
Like in the dark ages, yes.
Well, so therefore, they have given it to him. Now he groomed the school. Well, he make the school grow, and after 30, 45, 40 years, the headman, the present headman only, he started claiming. All the previous headmen for 35 years, no one claims. No one claims. Now, only there for the limited purpose is whether the order passed by the STSUO giving approval to the SMC of the private respondent is correct or not. That is the issue, my Lord. And the second one is...
Now you see you're retired, you're nowhere in the picture, you've done your service to the school. Why don't, who's for the school? You're appearing?
My friend is appearing.
Make him honorary member on the management committee. Make him honorary member on the new management committee. He done a lot of service for the school, 40 years.
Well,
even the MC has expired on 4th.
Maybe
it expired also.
MC is the interim arrangement. They have taken over the school.
This matter has become infractions with regard.
Now who's looking after the school? Who's looking after the school now?
Just expired on the 4th.
4th of March. Now who's looking after the school now?
What happened is this, my Lord. Two schools are there. One, the school, my school, which established 1978, and I run from there from 1980. Now from 2017, private respondent established his own school. 2017.
Your school from 76?
Yes. And now he ran the school.
What happened to the school, 76 school?
Well, I ran throughout. Now what happened is this.
Is that school still existing?
Yes, my Lord.
Over and above the village school?
No.
The two schools?
No, two schools are there, my Lord. Therefore, I'll clarify.
You're running two schools?
My Lord, yes.
How is that possible?
My Lord, Your Lordship, give me. The school, LP school here, was established in 1976 by the village. Village run the school with the contribution of the villagers.
Whose school established? Your school or village school?
I'll come to that, my Lord.
Yes.
So 1976, village established the LP school, run the school from the contribution of the household. The household unable to contribute the funds. Therefore, they hand over the entire management of the school to me from 1980. And I ran the school.
You had your own school also?
Yes. I ran the school. Now, in 2017, after the private respondent became the headman, he established his own school with the grant of the government. Government constructed the building, and he runs the school 40 meters away from the
government village. Gave a grant to the private respondent to establish a school.
Establish a school.
Over and above the village school existing,
yes.
You are running. Okay.
Yes. My Lord. So the
same name?
It is not the same name. It is different name. He ran the school. Now the school completely failed. Now what he has done is that he came and occupied the school. his entire family is staying in the school. And now...
Which in the own school which he built?
Yes, in 2017 with the government. Now he resided in the school. Now he is taking the name of my school now, LP school, and he is running the school in the community hall.
No, that's all disputed facts. How it is?
My lord, therefore, my humble contention is whether the approval given by the SCSO managing committee in his favor is based on the records or not. That is the only question involved here. And second question
now,
is...
Now if the managing committee does not exist anymore, and you're disputing that, the constitution of that managing committee, then we'll ask the SDSEO to have a fact-finding inquiry, take all his statements, because these are all facts. Whether he had a school in 76, or whether it's a village school, or whether he made a school in government funds, and he's staying out there himself, and running the school in community center, that is all. How will the court decide?
My lord, if the lordship wants to appoint a fact-finding committee, like director, impartial person, they can do that, my lord.
Yes.
And take the statement from all the...
Okay, we can do that. Now what happens to you? You're a retired person.
No, my lord.
Now how do you want to cling on to something which is, the school's given to you fine by the village?
My lord,
now it's over. They can give you a medal or something for all the hard work.
My lord, my humble submission is my service rendered to the society, to the school.
Should be
cannot be, my lord, cannot be with the term of my service.
Wished away, but the thing is that what role can you play now? You're no more. You're not eligible to teach anymore. But now, how can you be the sole, arbitrator or decider who decides who will be in the managing committee? And
no, my lord, I'm not the sole person. My lord, the managing committee is formed by the sponsoring body, the representative of the teachers.
You said that you are the sponsoring body. You run the school handed out to you. So all these 40 years, it is you ruled it.
Right.
Correct.
I run the school.
You run the school. Now you're retired. Now you run the school. You constitute the managing committee yourself. Who should be members? Correct.
Right. Every
because
3
you're
years.
the sole sponsoring body. Okay. Now you're retired. The school originally belongs to the village. So what will be your role now? What do you envisage? How do you see yourself being involved in the school? What do you want to do?
My lord, the handing over of the school in 1980, it is not a conditional handing over. It's absolutely...
They gifted it to you.
It is a gifted to me. And therefore
Is that possible?
My lord. Therefore I have given all the resources. I sponsored the salaries of the teachers, the helpers, the management, infrastructure development.
But you have derived some benefit also.
No.
Doesn't mean that you did charity from 40 years.
No, my lord. Therefore,
you've done charity.
My lord, that is why.
You've done charity, then why should they fight for it? If it's a charitable thing, no one will fight for any charitable thing.
I don't derive any benefits. I'm only a teacher of the school, a founding teacher. I don't derive any salary, my lord. Rather, I spend from my own pocket to develop the infrastructure of the school. Even the non-sanctioned teacher's salary, I used to pay it. It is not the case of the village authority.
We can't...
They pay.
Yes, we'll dispose of that then.
My lordship, give me, I'll just highlight a few facts with regard to first petition.
It's all right.
And second petition.
Yes?
Lordship, second petition relates to taking over of the management. Now the UP school, the second petition. Now the law is very clear. Meghalaya Education Act is very clear. Before taking over, inquiry should be there. An opportunity to rectify any mistakes if committed by the managing committee is there. And if the managing committee failed to rectify, then the government can issue show cause notice to me as to why school should not be taken over. And thereafter, my lord, hearing me, they can take over the management of the school. Now here, in the second petition, without any...
Mr. For number 5. Sorry, just 1 second. Yeah, for number 5.
First petition.
Item number 12. It is item number 12. Yes. What do you say?
Item number 12, they have not made a
in this item?
This item
they are not a party. Second item, they are not a party. First item, they are a party.
Item 11. Okay. What do you say? Item 11. What do you say?
Whatever the case may be, the school should be a village school. Not,
that's it. Okay. Now what do you say about item 12?
Second item, my lord, lordship. My lord, there is a blatant violation of the Meghalaya Education Act to take over the management. If I can show, my lord, the Meghalaya Education Act.
No, but what, you are retired at that point of time already. You're not in the school anymore, correct?
My lord, I'm not the teacher of the UP school. I'm the teacher of the LP school, my lord. Here, 2 schools are there. One is LP school, one is UP school.
You have no connection.
UP school also given to me, my lord. That is the case, my lord. If lordship kindly see the Act, my lord. I'll just point out the provision of the Act. Then lordship, Meghalaya Education Act 1981.
Yes.
My lord. May I come to, my lord. Section 24 of the Act.
What does it say?
My lord,
it's here. Yes. No, don't worry, it's here. Yes.
My lord.
Yes.
It clearly says, my lord, inspection of the schools. It says,
yes.
Every recognized school shall be subjected to inspection as may be prescribed. Now, the director may give direction to the managing committee requiring the management to rectify any defect or deficiency.
What do you say about UP school?
With regard to UP school, my lord, because they have taken over the management.
This is with regard to UP school?
UP school, my lord.
Where does it say
Secondary
that?
petition, my lord.
Where does it say in the Act that with regard to UP schools, certain procedures prescribed for taking over the
management?
Yes,
my lord. Section 24 I'm reading, my lord.
24 doesn't talk about UP school.
But it refers to, my lord, the school.
It just says the state government may delegate or every recognized school shall be subject to inspection.
If we see the, my lord, definition of the school, my lord, it will come, my lord.
Yes.
May just come to the definition.
Why are we in a hurry? Because this case has just been lying for so long.
My lord, therefore, my lord, I'm also interested for disposal of the matter, my lord.
Recognized school means only school, recognized by the appropriate authority. It's very vague.
Well, we'll just come to the definition of the school.
School definitions at section 3,
section 3,
21. You see there.
My lord, page number
321. Section 3, subsection 21.
21, school. School includes pre-primary, primary, middle, and high school. My lord. It's
everything.
My lord. So this is upper primary school, class 5, 6, 7, 8 falls within
There's
high
no
school.
distinction between a pre-primary school, primary school, middle school, junior school, high school.
Yes. So school is there. Now, therefore, how the government will take action, section 24, my lord, can kindly come to section 24. Now, 24, lordship, kindly come. Section 24.
Yes, that we've seen.
My lord, subsection 3 says that the director may give direction to the managing committee requiring the management to rectify any defect or deficiency found at the time of inspection or otherwise in the working of the school. If the managing committee fails to comply with the direction given under subsection 3, the director may, after considering the explanation or any report, if any, given or made by the managing committee, take such action as he may deem fit, including, my lord, except the minority school, taking over the management of school under section 20. And lordship kindly say section 20, my lord.
Yes.
But section 20 may I read, my lord. It says, my lord, taking over the management of the schools, whenever the government is satisfied that the managing committee of any school, whether recognized or not, has neglected to perform any duties imposed on it by or under this Act or any rules made thereunder, and that it is expedient in the interest of the school education to take over the management of the such school, the government may, after giving the management committee of such school a reasonable opportunity of being show cause against the proposed action, take over the management of such school for a limited period not exceeding 3 years. My lord, I may come to section 3. After taking over the management of any school under this section, the government may arrange to manage the school through any person or officer authorized by the government in this behalf, hereinafter referred to as the authorized officer. Now, may I come to 4. Where the management of any school has been taken over under subsection 1, the managing committee of such school may, within 1 month from the date of taking over, appeal to the state government, who may, after considering the representation made by the managing committee, pass such orders, including an order for the restoration of the management or for the reduction of the period during which the management of the school shall remain vested in the government as it may deem fit. And the subsection 5 talks about the giving of rent to the.
Yes.
Now, when we come to the impugned order, my lord, in my second petition, lordship, I'll just second petition. Now, what they have done, my lord, they did not furnish the copy of complaint also, but they have annexed in the affidavit filed by the director. May come to the affidavit filed by the director. Their detailed documents they have annexed.
Yes.
My Lord, director has filed the affidavit on 17 May 2022. Mr. Ambrose H. Marak.
Now, 1 second, coming back, before you come there, he aggrieved in the first petition, from the prayer, you're asking for recognition of the managing committee which has been proposed by you, single-handedly, correct? In the second one, you are aggrieved with the dissolution of the managing committee of your school.
Yes. And
dissolution, this is your managing committee.
My dissolution, yes, my management dissolved.
In 20th December 2021, it was?
Yes, and they have formed the new managing committee, interim committee.
Under the response number 5.
Yes, and taken over the management.
And why didn't you make him party in the second petition?
No, I made them as a party. Interim committee is there. Interim committee is there, headed by the government, in the second petition. After
yes,
dissolution,
fine.
My Lord.
Yes, interim arrangement is.
My Lord, may see the impugned order in my writ petition, second petition.
Because we'll dispose of this
page
matter.
55. Page 55 of.
Which area is this? The dissolution of the managing committee of Morapat, so and so.
My Lord, page number 54, my Lord.
And so?
So my managing committee was dissolved by this late order, and interim committee headed by the SDSU was formed.
Where is that interim committee?
My Lord, page number 54.
This is 7th October 2021, and this other letter dissolution is 20th.
My Lord, this order is 10 December 2021. They refer to the 10 October.
Yes. No, that's what I'm saying. It's prior to the dissolution order. How is it possible?
No. Therefore, my Lord, your Lordship, can you see the...
No. Please let the court understand. Now, this 20th December 2021 is dissolution of school management committee and resolution on changing the OK.
Well, so when they issued this 10 December 2021,
One second. Okay, yes.
Well,
that is fine. 10 December was dissolved, actually.
Yes, my managing committee was dissolved.
Yes.
When it was alive.
Subject school's president, he's continuing.
Yes.
Very good.
And now, my Lord, the affidavit filed by the director, they have given the detailed documents. May I just show, my Lord? By director of school, Mr. Ambrose H. Marak.
When was it filed?
He filed on 19 May 2022. I received that copy.
Very good.
And my Lord may come to page number 15. 15 of the affidavit. This is the complaint for dissolution of the school managing committee by the village headman and secretary. And this was not given to me. These are the a number of allegations are there. And what happened thereafter?
Now, what is this? This is your complaint.
This is the complaint against me by the headman and secretary. And my Lord may come to page number 19. On the basis of that complaint, government has taken the step.
Yes.
And it says, my Lord, it was informed to the director. Now, reference to subject, I have the honor to forward here with a copy of the letter from the Bashnong, under reference requesting the dissolution of the school managing committee. So it was referred to the director.
Yes.
And thereafter, director has taken a prompt step, page number 20.
Wrong step.
The effective step, my Lord, they have taken step.
Effective step.
Page number 22.
Okay, 1 second. I'll just go to EO.
Page number 20, my Lord.
Okay.
By page number 20 now, in charge director has directed the STSUO, my Lord, to conduct a spot inquiry. My Lord, I instruct you to kindly carry out an immediate spot inspection in view of the reason mentioned before any course action can be recommended. So this is the and page number 21. Now, this STSUO has given a letter to the managing committee. Now they say this is the letter given to me, we never receive. And there is no, my Lord, evidence of how we receive. My Lord, this is written to us on 9 August, addressing to us It says, I have the honor to inform you that this authority will conduct a spot inspection on the matter related to dissolution of the School Managing Committee of Maropa Sansaj on 13 August. So now they said this was served upon us, but we never received them. We never received. And thereafter,
how can you prove that you haven't received it?
We never received.
You received it, so
we never received.
Okay. Yeah, what happened after that?
Page number 22 thereafter. Now, page number 23 is the inquiry report.
So the entire students of school is 16.
16,
Class 6, there's 7.
Well, it is.
Class 8, there are 5, and class 9. Class 7, there are 5, and class 8.
Well, it is a COVID time, because of the COVID time. It is a COVID time.
How is that possible? We're not talking about, they're talking about the enrollment, not about the students that are present in the school.
Madam, that's true. It is a very, very small village. It is a very small village.
There can't be 16 students. All these villages have a lot of students.
My lord, as per the last year enrollment, my lord, for LP school, 39 students are there, and UP school, 18 students are there. But it is a small village. And the school of my friend, my lord, 6 or 7 students were enrolled.
How many teachers in your school?
In the LP school, my lord, 2 teachers are there. And UP
How
school.
many students are there in LP school, in your school?
My lord, 39.
Very good, 39 LP school. And UP school, how many teachers are there?
UP school, 18, my lord.
How many teachers are there?
In the UP school, 4 teachers are there.
16 is here. So 4 teachers. Very good ratio. That means one teacher for 4 students.
Well, it is a very...
You don't get a ratio anywhere in school in Shillong also. Out here, 1 teacher, 50 students.
Yes, madam.
Yes.
Madam, it's a very small school.
This deserves a thorough inquiry if the schools are running at all. Do teachers go to the school? They present or they don't teach?
They teach. Otherwise, how can they run the school?
You'll be surprised, but that is the situation that's prevailing.
They run the school.
We're going to start a program. We started 19. It got hell of COVID from Malsa regarding back to school for children, especially the villages who have dropped out of school earlier on, and now, especially COVID, who never went back. And we're not only faced with that situation of school, even teachers also, for them to be back to school. Yeah?
Well. Now, with Lordship permission, may I come to that page number 23?
Yes,
this is the inquiry report.
Before me.
And page 22 is the inquiry report submitted to the authority. And thereafter, they dissolve my...
See, look at this. Look at this report. It's very damning. Now look at low enrollment, 16 only dropout students. There's a lab coordination village administration in the school. And the school does not have any record of students. There's no follow-up case if any dropouts exist also.
My lord, what happened on this day, my lord?
They never implemented the midday meal scheme for many years.
My lord. My lord.
That is the right. There's a children's right.
My lord. I'll come to my affidavit with regard to that.
Now you don't utilize the grant in aid, salary of teachers.
My lord, this is the allegations.
You have not maintained the record with regard to appointment of teachers.
Yes, my lord. That is the allegation. Now
there's no representative police Darban school management committee since so and so.
Now what happened on 13 August, my lord?
School very poor hygienic condition.
My lord. They can make whatever.
What more bad report?
My lord. Therefore, I'll show in my rejoinder. What happened on that day, my lord? The STSO came to the headman, and after they said that they called the petitioner that we are coming for inspection your school. Be there within 10 minutes. So they came. Now they came for inspection.
You were there also in inspection?
My lord, I was informed over telephone. And my lord, the inspection was done. No record was perused, my lord. And they said that we will dissolve your school, and they returned back. Now the allegation that midday meal school no granted it is properly implemented. Lordship, we kindly see my rejoinder. Now, before I give
go there, Mr. Chariso.
Rejoinder, my lord. Now, therefore, this
is a document of the state respondents.
No, therefore, my lord.
By some set of schools.
My lord, even my lord, assuming that the inquiry report is correct. Now, the procedure, my lord. Thereafter, they furnish the inquiry report.
Procedure. These children are suffering.
My lord.
They're getting midday meal. It's poor hygienic condition in the school.
That is not in ground.
That is not
the ground reality.
Everything is here for public policy and public interest, Mr. Chariso. Just to suit the egos of some person who wants to take control of the school. This court will not stand. We will not allow that.
Lordship, my lord, I really
and if the petitioner wants to stand on an incorrect procedure. This is the report of the school. Right. No record of dropouts, no record of the students, no record, no how petitioner appointed, no record, no implemented midday meal scheme.
My lord, therefore, my lord, they never looked at the record. It's just only a report, my lord. It's only a report. Therefore, we implement him as a party, the STSO in person. There was no inspection. Now, the act is very clear. After inspection report is received, adverse report is received. Now, the government has to give me a show cause notice that these are the deficiency, you rectify it. If I don't rectify, they'll issue show cause notice for taking over. They don't follow this, my lord. Straight away, they took over the managing committee. And in my rejoinder, my lord, I've given the detailed evidence how I implement the midday meals.
Then we'll appoint an advocate commissioner to go and do inspection.
They can do most, my lord. The writ petition is most welcome, my lord. If any third party come, not the STSO, any third party, government officers or the the learned advocate come for fact-finding inspection, my lord, he is ready. Even the teachers are ready. Well, this is how the village headman, after he became, he took over, he stayed in his own the government building. Now he's running a school in his...
one thing, Mr. Chairman, whatever it be, there might be other conflicts you might have with the village, another school. But the sum and substance of the matter is that if you have been doing what you've been doing a great job or something, an inspection was carried out in your presence. If everything was fine, then yes, there's something that is wrong that they're trying to oust you for no reason. Yes. But if the report is such, the entire upper primary school, there are only 16, there's 4 students in one class.
They're formed.
I mean, what is happening? I mean, the grant in aids. How you're getting grants in aids from the government? How you use that? There's no record. You have not implemented midday meal scheme. Also, do you have a cook for midday meal scheme in your school?
Yes, the cook. My lord, the cook is appointed.
Where's the name of the cook? What's the name of the cook?
My lord, therefore, in my agenda, all the details are there.
Because you can't have
details are there. Now, this report is a focus report, cited with the village headman. Never based on the records. And if Lordship can see my affidavits.
Cash memo showing you bought carrots and tomatoes.
My lord, if Lordship can see my detailed affidavits, rejoinder, all the materials are in annex.
Inquiry, there'll be a fresh inquiry then.
My lord, Lordship send an impartial person or officer to conduct inquiry. Even the member of the bar.
Rejoinder affidavit which have been filed, especially with regard to midday meal, my lord. If my lord will see page number 10, that is a utilization certificate. Lordship will see that, my lord, this utilization certificate has been certified by the petitioner himself. This is not present with us, my lord. In the government record, none of this document present. Only once we file our affidavit of opposition, bring the inspection report, my lord, midday meal has also been misappropriated. They brought it into record, and that is
rely on these documents given by them.
Himself, my lord.
There is no in the affidavit. There is no government of misappropriation of midday meal.
The person who received the grant can utilize, can pass the utilization certificate, my lord. That's the one question, my lord.
Lordship,
I'm giving the my lord grant. I should be certified.
That will
the document, my lord. He is certifying himself.
My lord, who is certifying? Either me or the government or the headman. Let the impartial person come for inspection.
I think.
That is my humble prayer.
Relax. Don't run the school anymore. You're retired now.
My retirement is one issue, my lord.
For 40 years, going on every 16 students in the school. That means a great job. That's all. 16 students, 40 years you run a school since 80. 16 students.
That is true, my lord. Off and on, my lord. Some years the student increase.
No record of any dropout, no record of any enrollment of people who have left.
And Lordship, no I just place one decision, my lord. The other side may say that I did not file an appeal before the government for this solution. For that matter, my lord, I just
appeal. It's okay.
My lord.
Take down. The first one is
WPC 172 of 2021, madam. Item 11.
WPC number 11. Okay.
172 matters become infractious, Your Lordship.
Yes. Infractious.
Yes. The managing committee expired on 4th
Okay,
March.
take down. First one on 172. 172. The writ petitioner who stated to be, what do you call yourself this time? Is he available in court, a petitioner?
No, no.
How old is he?
My lord, he would be now, I'll just see the affidavit.
The writ petitioner who claims to be the president.
Now he would be 67, my lord.
67?
67.
Yes, who claims to be the president of, this is the managing committee of Maurapat UP school.
He would be 68, my lord, 68.
Okay. By the incident petition has prayed for the approval of a managing committee which was constituted on 12/2/2020 for a period of, it was constituted 12/20/2020. Stop. The claim of the petitioner is based on the facts that the school, initially known as the lower primary school at Maurapat is PAT or PAD? PAD. Yes, was established by the village. It started with one of the seven of the village. By the Darbar Shinong, yes. By sponsor, the Darbar Shinong of Maurapat in 1976. But due to shortage of funds, the respondent number 7, by an agreement dated 15/3/1980, handed over the school to the writ petitioner, who thereafter managed the school single-handedly. Correct? Single-handedly.
No, with the managing committee, my lord.
Managing committee is your managing committee. Was it your family or who did you employ in managing committee?
My lord, that is the allegation. Even when we see the managing committee of the other side.
I'm just asking very fairly, Mr. Chare. So now all those years when you made, you're a sole sponsoring body alone.
Sponsoring body.
It is under your signature that anyone became managing committee member, correct? Yes. Now, who were the members last which reconstituted in 2020?
The members.
Yes, 2020?
The members, my lord.
What approval?
My lord, I'll just reflect that managing committee.
That is that page?
Page number 35.
Okay, who are these people?
35, my lord. I'll just find out in my agenda, it is reflected there.
No, just the managing committee, 35A.
My lord.
Now, you're a secretary.
Strictly is the secretary, my lord.
Who's Rishad Shangdiar?
Shangdiar, my lord. He's a nominated member.
Who's he? President? Who's president?
My lord.
Who's the president?
President is Rishad Shangdiar, my lord.
Who's he?
My lord, this is a detail, my lord. I'm not aware.
Is he a village sardar?
Affidavit, my lord.
Is he the village? He's a village functionary. President?
My lord, that one. Whether he. In my agenda.
Yes, Mr. Kirim. Who's Rishad Shangdiar?
Son of Shangdiar.
The son. Okay, then who's Kansaibor Shangdiar?
She's the son.
Another son. Then who's Thelis Srimati Shangdiar?
She's the wife.
Wife of Strictly Simli. No.
She transferred the land.
She's a wife, his wife.
Wife.
Okay, wife. Then who's Hamlan Sons Imyong? Teacher. Okay, then who's Kmenlang Shangdiar?
He's also son.
Son. Then who's Ebostar Milliam?
Son-in-law.
Son-in-law. Okay, then who's Happy Man Shangdiar? Son. See, Mr. Chariso.
My lordship.
Family business.
What would the point out now? If lordship just give me to point out the members of the private respondent number 7. Lordship, kindly see page number 6.
Not going to number 7. We're going only on your petition right now.
My Lord, Lordship is taking
We're
cognizance.
going on your petition. We're going on the first petition, Mr. Chareso. Number 11, where you have come to this court for non-approval of your managing committee, which was reconstituted in 2020.
Managing
correct?
committee.
Yes.
And Lordship,
And
kindly
17, in 17 also all son, and same thing in 20, correct? These are the members.
Well,
so,
and Lordship, kindly see the member of the managing committee formed by the other side.
They won't go there.
They also
will not
my
go
son-in-law.
If there's a new, if there's a new regime that's going to come, it'll be fair and square to all the villagers. That's all.
That is
now
true.
there's no more managing committee existence.
My Lord, the managing committee of my...
Enough 40 years and you're... there's a limit. There's a limit. Son, wives, 3 sons, 1 son-in-law, your wife, yourself.
My Lord.
If managing committee kitchen I think managing committee meetings done in the kitchen then.
Lordship, we appreciate the other side also.
We don't appreciate anything.
How
we appreciate
they
how
also
you run the
son-in-law.
school. And what is your basis of your current claim now?
They are also son-in-law, father-in-law. See the composition of the managing committee of the other side.
Let the proper sponsoring committee be sponsoring body be constituted by the villagers. Then let them elect in a darbar the members of the managing committee.
That can be done, my Lord. I'm not opposing for the formation managing committee. My Lord. If they object my composition managing committee, they also say father-in-law, mother-in-law.
One, Mr. Chareso. I'm sorry to say.
Lordship is appreciate that these bogus members are there. As much as my Lord.
If there be bogus, yours are bogus also.
In that case, Lordship may direct for formation of a new managing committee.
Then you are out of the school totally. You will have no more right to even enter the premises of the school, nor have any say in any activities. Your rights will be extinguished because you have run the school 40 years and have 16 students, and the managing committee has been constituted by your family members only. There's no interest of the villagers, no interest of the school. The children are the last interest in your mind. All interest your own pocket and for your family.
But that, with due respect, my Lord.
With due respect to you, Mr. Chareso, it's not you, it's your client I'm talking about. So that's the thing.
My Lord, we disagree.
Otherwise,
we disagree with that.
Problem? Yes. Yes. My school till 2020. My school till 2020. So it appears that the non-approval of the Constitution and Managing Committee of the petitioner was due to the fact that another Managing Committee, which included the headman and secretary of Respondent number 7, had since been approved for a term of 3 years with effect from 5/3/2021 to 4/3/2024. Where's that order? Implement Order 93/2021?
That is Annexure 20, page 66.
Yes. No. The managed committee of the village has been approved.
That is the one in the first street which Lordship was looking. Page number 66.
See,
this is the one.
Where's 9321? Where's 9321 order? The Constitution. Not Annexure 20. Annexure 20 is his managing committee. I'm talking about 2021.
My Lord, that is, my Lord, 9 March 2021
yes,
is
where's that? Yes.
Page number 66.
Good. 66?
66.
Okay.
Same members, President Secretary and the father-in-law, son-in-law of the petitioners.
Not be
The respondents.
Managing Committee of the respondent number 7.
My lord, this is the one.
No.
My lord, my proposal is, my lord, I just show.
Okay, sorry. This is not 2021.
It is
What is that? Oh, sorry. I
order
looked at it on top.
at the bottom it is reflected
Yes,
there.
Sorry.
My,
My mistake.
It's
Top, no?
9 March, my lord.
Yes. No, I look at the date on top, 1512. Yes. So, the said managing committee, the said order whereby the managing committee has been approved, fines placed at Annexure 20 to the writ petition. So, without delving into the facts and merit of the case, what can be seen is that the managing committee, which is impugned with the impugned order dated, what can be seen from the records is that the managing committee, which had been approved by the impugned order dated 9/2021, has also run its course, inasmuch as the term was till 4th March 2024. Stop. So, therefore, at present, there is no managing committee which has been reconstituted or is functioning in respect of the Moro Parts LP school. Correct?
Yes.
LP school. So, next paragraph. This writ petition has been filed by the writ petitioner, or Mr. H.L. Changriso, submits that this writ petition has been filed on the premise that the respondent number 7 had not only handed over the management of the school to the writ petitioner, but in fact had relinquished all other rights, such as title, etc. And since the handing over, the school was entirely owned, managed, and the writ petitioner was a sole sponsoring person of the managing committees that were constituted thereafter. It is therefore contended that the respondent number 7 has no authority or right to assume management of the school and to constitute a fresh managing committee. So, certain other arguments have been forwarded by the learned senior counsel based on the averments made in the writ petition, which, however, are not statements, of which, however, are in the realm of disputed facts, which this court, sitting in Article 226 jurisdiction, cannot enter into or adjudicate. Stop. Next paragraph. What's the submission, Mr. Abraham?
There was also an inquiry with regard to the handing over of the school to the
school.
Yeah, that
inquiry is here.
Yeah, it's
Yes.
in my affidavit.
Mr. H. Abraham, the government advocate, in his submissions, has relied upon the affidavit filed by the state respondents that the writ petitioner, that in connection with the affairs of the school and with regard to the claims and counterclaims of the writ petitioner and respondent number 7, a spot inquiry, sorry, it's on a complaint, yes. Tom?
There was an inquiry report.
Affairs of the school? No, in regard to affairs of the school, a spot inspection has also been carried out due to a complaint against its functioning under the writ petitioner. Stop. The spot inspection he submits has revealed a very sorry state of affairs, with the enrollment standing at only 16 in the upper primary section. Stop. He therefore submits that it was in this backdrop that the managing committee, as proposed by the writ petitioner, was not approved. Stop. Mr. B. Kiriam, appearing upon number 7 of the submissions.
The school should remain a community school.
Yes, has maintained that the school, which was initially set up by the community, should remain with the community, and that the writ petitioner, in running the school, in managing the school, as a sole proprietorship is untenable. Which he submits is reflected in the proposal for reconstitution, wherein the members are all the family, apart from a teacher of the petitioner. Stop. Next paragraph. This court has considered the submissions and has also examined the materials on record, as also the spot inspection report dated
on 7 February 2020.
7th to 2020. Now you're out from the school since that time. You're not more involved in the school from that time, correct? You're not any more involved in the school since 2020.
No, but we are still there, my lord.
How are you still there?
My lord, we are not running. My lord, therefore the managing committee of private respondent number 7, they have their own school, they are running there. They never come to the school. They never look after the welfare of the students, even the teachers also.
Very good, yes.
That is it.
Not that problem. Yes. Next paragraph. Understand. Notwithstanding the spot inspection report, the fairness of which is questioned by the writ petitioner, as observed earlier, due to the presence of disputed facts as to whether the claims of the petitioner, the claims, counterclaims of the petitioner, respondent number 7, are correct. It is deemed necessary to correct, and whether there exists more than one school, as has been argued. This court deems it fit at this stage, especially taking into account the fact that the approved managing committee has since expired, to direct for an inquiry at the level to be conducted by the Who? Mr. Abraham.
By Director, Your Lordship.
Director of School Education?
Director of School Education, yes.
By the Director of School Education into the affairs of Maurapat LP and UP school. Stop. Opportunity, needless to add, adequate opportunity of presenting the facts and materials should be accorded to all interested parties. Stop. Next, on a footnote, this court notes with deep concern the manner in which such schools are being administered and run, inasmuch as it appears that the interest of the children for whom these schools are set up and established have totally taken a back seat with the persons at the helm instead of promoting the cause of the children are busy, should I write, feeding their own egos? Yes, are busy in all other activities except the primary, except the stated objective of providing education. Stop the inquiry. Next paragraph should preferably should commence immediately, and a report should be generated within a period of 2 months.
Yes.
From the date of receipt of order by the Director of School Education. Stop. The terms of reference for the inquiry shall be left to the wisdom of the Director of School Education after conducting a preliminary hearing.
Yes.
Because the managing committee has expired.
Yes, as the managing committee has since expired, the subdivisionals, was it as the SEO, shall look after the affairs of the school until further orders. Yes. And number 12?
I may be allowed to have a copy in this case, Your Lordship.
Why? You can download it.
I'll have to forward to the department now.
A certified true copy of the order be provided to Mr. H. Abraham, Learned Counsel for the State for onward transmission and compliance. Yes. Number 12? What's there, number 12?
This is it. UP school, my lord.
So this will cover both the cases?
It will cover both. It will cover both.
What's the prior in number 12?
Number 12 is, my lord, by illegally dissolving my managing committee.
Next matter, number 12. In view
and
of
installing
the
interim
order passed
committee.
in WPC number, this is number 12. Number 497.
Second WPC is, my lord, 44. 497. 497.
174.
No, 497.
First one is 174.
This also till 4th March.
No, Your Lordship, until further orders. The SDO is managing until further orders, Your Lordship.
The SDSEO. Where is that order?
The order is page number 54. It's interim committee, my lord. They have formed.
54.
54 of the writ
No,
petition.
for this item number 12. Where is this until further orders?
54 is the interim committee.
Now it's Annex 11.
Annex 11, my lord.
Where's the until further orders? It just says that the interim management committee has been constituted to take over the management and look after affairs of school with immediate effect to the new school.
Managing committee, sorry, Your Lordship.
Huh?
Managing committee is constituted till a new managing committee.
In its next petition number 497. Stop. In the petition which is connected to WPC number 172, wherein orders have been passed for holding of an inquiry. The same directions will follow. An inquiry will encompass both the LP and UP schools. Next paragraph. However, as interim management committee headed by the SDSEO is in place, the same shall there is no necessity. The same shall continue until further orders. Yes. Copy of this order also be, and you say that is same time limit. Yes.
Item 13. 13.
My Lord,
yes.
The last occasion, my Lord, there was an order passed that Dr. Mozika was to obtain certain instruction as to whether they apply.
In fact, I was informed that we're still awaiting the instruction. If
you want to close contempt, Mr. Pathak, you said?
My Lord, we want to, but then if this is the order they have
next
passed
week.
in us
Your Lordship.
first.
Next week. MS Rumthau submits that instructions will await this matter next week. It is expected that the matter shall be closed. No, not again. Next week. Yes?
13 and 14.
21.
Yes.
May I please, Your Lordship? Conducting counsel is engaging in another court, Lordship.
Isn't the where?
DB, Lordship.
There's no DB now.
Single court of Chief Justice. But Your Lordship, one thing is this, last, initially it was argued on 4th September. Thereafter, continuously.
No, you were absent also after that.
No, only 15th, Your Lordship. I was absent on 15th.
We long adjournment.
No, Your
After
Lordship.
1 week is as the County Council for spot number. We accommodate you a lot.
Your Lordship, yes, Your Lordship. But on 15th only I sought adjournment, Your Lordship. Continuously after September, it is.
Next day.
Yes, Your Lordship.
Can't take in his absence, we can't take it up. Also.
Yes, Your Lordship. I am not objecting to that, but short date may be given, Your Lordship.
Yes.
22.
You tell the court master.
Yes, Your Lordship. 22, same, Your Lordship, connected matters. Both the matters are connected.
23.
Please, Your Lordship. You received the appellant here in Your Lordship. Just last week, Your Lordship, she passed away, Your Lordship.
Who?
The appellant here.
Appellant.
So I'm praying I may be allowed.
Who's the successor interest? You found out?
Yes,
Who will be the heir?
Maybe her daughter, Your Lordship.
Mr. That's correct, Mr. Sangma?
No, the information has been provided by
Mr. Dean Newton, counsel of the appellant, submits that the appellant has expired on?
Just last week, Your Lordship. I didn't remember exactly.
At least have since expired, he prays that we be allowed to bring the successor interest on record by way of substitution. This prayer is allowed. Just after 4 weeks.
Obliged.
Next items are connected. So we be allowed to take steps because the next item is a contempt petition, my Lord.
Take steps for contempt against this lady?
That's right, my Lord. So
then that was gone.
Yes, exactly. So
contempt can be closed?
No. Contempt is for two, my Lord. There are two respondents.
Then that let the matter come out of 4 weeks after it gets substituted. Yes.
Right.
27.
Your Lordship, my conducting counsel is in another courtroom.
Conducting counsel?
Huh?
Who's the conducting counsel?
Adamnath. Respondents.
Where's the petitioner? Even last time, none appeared. This is the second occasion that none has appeared on behalf of the petitioner. Stop. Matter shall stand dismissed on the next date if no appearance is made of the petitioner. Right.
28.
Your Lordship, if this matter may be taken up next week, Your Lordship.
Yeah, Mr.
G. Sinkram.
Are you functioning as Secretary of the Bar Council?
Yes, Your Lordship.
We'll have some words for you. Yes?
If this matter may be taken up after next week, Your Lordship.
As per the last order, Your Lordship, this already made objection.
Last opportunity.
Where's
MSE Wanyan?
Lordship, I'm appearing for respondents 5, Lordship.
You ready? What's the matter about?
It's regarding the wrongful rejection of the application of the petitioner for drilling of water.
What happened, Mr. Abraham?
I'm not keeping well to argue the case,
You're
Your
not feeling
Lordship.
well. He's not feeling well today, so on that concession, yes, as Mr. H. Abraham submits that he's not well enough to argue the matter. Where's Mr. Kinjing?
He's
this is the matter after 2 weeks, yes.
And a bridge, Your Lordship.
Next is expected next week. The matter shall be heard in this post of
At
endeavour shall be made to.
This is a pensionary matter, my lord. Gratuity was not released. So our stand is the same. We are overburdened.
Gratuity with interest or just gratuity? Asking with interest?
Yes, Lord.
Yeah, he's asking for the interest, my lord. So, my lord, it is his right, my lord, legal right, my lord. My lord, only my prayer will be this, my lord. The entire amount we are ready to pay, my lord, but in installment, my lord. But because the amount is big amount, my lord.
In installments?
In installments, my lord. He has no objection, I think.
How many installments?
So we will try to complete within a year. We will try to complete the entire amount, my lord.
What is the entire? What's the amount?
It will come to 20 lakhs, my lord.
20 lakhs?
Yes, my lord.
So EMI per month we have. EMI equated monthly installments. It means that only. Yes.
So, and the rate of interest has gone down now, my lord. It may not be the same interest, my lord, has given in the.
That's 6%.
Now it is.
No. This is how much interest?
6%, my lord.
If you've already computed the amount, correct?
Yes, Lord.
Where's the affidavit? Where you said the amount? Yes, gratuity is a right, you know.
Yes, my lord. That
So
we
you
cannot.
can't
Yes, my lord. I'm
negotiate
not
with
arguing on that point, my lord. Our stand is only on page 4, my lord.
So the amount, where's the amount?
The amount, my lord.
Amount will be fine
Where's
in
the
my
amount?
Amount is in the writ petition.
in my
my lord.
writ petition, Lordship.
Writ petition.
Page 9 and 10.
In my
In 12 monthly installments.
not
No, my
exactly
lord,
12.
12.
Maybe 5 installment will pay, my lord. Within a year.
Five?
Yeah,
Three installment, my lord, within a period of 6 months at the most, Lordship.
My lord,
3
6
installment.
months will be too less, my lord. My lord, even
My
we are
lord.
not in a position to pay the salaries.
By 1 year, Lordship, that will be 4 years, Lordship, more than 4 years, Lordship.
My lord, we are in a position, my lord, where we are not even able to pay the salary of the staff, my lord, for so many months, my lord.
If it is 6 months at
Yes,
least.
no, they are being hands down,
Yes, true, Lordship.
bend down, everything.
Everything, my lord, is like, my lord, we are in a
Are
very
you
tight
getting
situation.
material instructions or no?
No, my lord, I have not even applied for.
My lord,
From 2015, I have not applied,
my lord,
but whenever I apply, they give something, my lord. It's not that they are
So
not.
all of them are working free.
No, I take care of them, my lord. I take care of them.
my lord will
She's
kindly,
working very hard.
Yes, my lord. She is very hardworking lady.
my lord kindly, one thing, kindly appreciate one thing, Lordship. If the direction
Where's
is
the
given-
amount?
that is page 9 and
14
10.
lakhs.
14 lakhs and for 4 lakhs, my lord.
Where's that? 14 lakhs, 39,000.
Or 10
Yes.
and 11, Lordship, 10.
Yes.
And page 10 is 4,99,520 rupees.
Page 10.
Yes, my lord.
10 and 11.
10 and 11.
Yes, Mr. SD has submitted at the bar that the respondents will pay the sums due of the gratuity amount to the petitioner,
Gratuity and leave salary, Lordship. Gratuity and leave salary.
the gratuity and leave salary to petitioner, but however, due to financial constraints, the payments may be allowed to be made on installments.
Yes, my lord.
Stop. Then what do you propose?
Lordship.
S.A. Sheikh, General Counsel for the petitioner, has no objection, but prays that the entire amount should be settled at least within 6 months.
Not 6 months, my lord, 1 year, my lord.
6 months, 1 year, Lordship. Otherwise, Lordship, what the client will think that, because they could have got it, since that is why they have approached to the Honorable Court, Lordship.
My lord. He is not only person.
And 4 years has gone, Lordship.
6 months will be too short for us, my lord. We are in
Okay,
a
8 months.
8 months, my lord.
Within 8 months from the date of the order.
My lord.
Then, Lordship, one clarification, that first installment, at least that amount would be high, and when he can make the first installment.
Expected that a substantial amount should be accorded as a first installment to enable the writ petitioner to tide over financial difficulties.
So far as the interest part, Lordship, that I'm relying that my Lordship judgment.
Yes. Interest as applicable by early judgments.
My lord.
Yes, payable at 6%.
If there is no specific, Lordship, that my Lord.
No, interest as applicable at 6%
Yes,
will
yes.
be
Yes,
will
yes,
be
6%.
will be given to the petitioner on the amount.
Yes.
6% they said they'll
Yes,
give.
yes, Lordship. No.
Matters
If there is a mention, then only they. Otherwise, they will
Interest
not.
is more important for my friend.
Yeah, obviously.
Of course, he has to have interest in interest.
Must.
Yes.
Supplementary item number 8.
Yes.
I have one notes. What is the other matter?
Number 8 is what?
This is the Weighbridge matter.
No, number 8 is subsequent.
Yes, subsequent, my lord. Number 8 is subsequent, no? Yes. Subsequent. Lord, you can
Number-
take a both, my lord, same issue involved, because it has some relevance, my lord. I'll come how it is. 299, my lord. That is also listed in the hearing column, your lordship. I don't know. Item 9. Item 9.
Item 9. 8 and 9.
No, which one should we take up first?
Lordship can, my lord, what happened, I'll just make the submission. So far 299 is concerned, my humble submission, it has become infructuous because the order impugned that has been withdrawn.
Okay.
So thereafter, what then? They, after withdrawing the impugned order, they had withdrawn the enforcement staff also. So being agreed, I filed the second petitions.
Then the second, the first issue will just have a bearing on this. That's all.
Some bearing,
Not
maybe
for
that's why
adjudication, not
Lordship
for
has kept
adjudication, but
if I refer, my lord, by chance, if I refer to some documents, then Lordship.
It's WC number 8 then.
Yes, Lordship can take it a bit.
Lordship, in 9, documents are all on record, even judgments are also on record.
No, which one? We will refer to it. It has a bearing.
Yes,
but let him
yes.
start
That's
on
what I'm
8,
saying.
yes.
If there is a bearing, I'm saying, my lord. I'm not saying anything
Yes.
indefinitely. Eh?
Yes.
Lordship. Petition.
But then we'll have to stop at. We'll give you. I think we'll recommence at 2.
No, sure.
You'll be there, Mr. Advocate General. We'll try to finish within 1 hour because we have some meetings at 3 o'clock.
Yes, yes, yes.
By 1 hour, be over.
It will take some time. I have to place those judgments also, my lord, on the power, government, everything, my lord.
Let Mr. Sen finish his
Yes,
part.
I'll finish 1 hour.
Yes, yeah, let Mr. Sen finish.
Finish it. Not keeping it like this.
Not 298. 888. Yes.
May it please your lordships. My lord, this the core issue here is, my lord, the settlement of a Weighbridge.
For 3 years.
For 3 years, then truncated it to 1 year, and which was challenged in the first arbitration. My lord, before I come into it, very briefly, I have jotted down. I won't take much time. Short, my lord, background. Very short background I will place before my lord. Now, my lord, the idea of Weighbridge, your lordship, is aware, my lord, in the motor vehicle access provided. Main purpose is to regulate the traffic. Now, it is also used nowadays, my lord, integrated check gates, that whenever the weighment is done of a mineral-laden vehicles,
yes,
after the weighment, the amount of the mineral is quantified. And that particular, my lord, quantification slip, that was used for the collection of royalty also. So it's up to end purpose. And they also check, my lord, whether it is overloaded. Because overloading, my lord, destroy the infrastructure. So these are the twin purpose. Now, my lord, in 2003, my lord, before 2003, my lord, there was no rules regulation as such. In 11 September 2003, government for the first time, my lord, notified certain executive instruction how to manage these Weighbridges. Whether the government will manage or government will use the private Weighbridges. So that notification came in 2003. So these were executive instruction. Till 2009, my lord, these were enforced. In 2009, my lord, under, my lord, Motor Vehicle Act 112, section 112, if I am correct, my lord, state government was delegated the rule-making power, how to manage the Weighbridges. Now, government of Meghalaya first time, my lord, formulated rules. Now, my lord, this was called, my lord, installation of Weighbridge Rule 2009. Briefly, I am referred to as Rule of 2009. Now, my lord, 2009, my lord, made elaborate arrangements. My lord, how? It said, number one, the Weighbridge, government can of its own manage the Weighbridge. No matter ends there. But government can also use private Weighbridges. Now, when it comes to private Weighbridges, my lord, there is a set of rules contained in the Rule of 2000. Now, how it is to be done? One requirement is, my lord, it has to be settled through tender. Has to be settled through tender, and other criteria conditions were laid down. And it specifically says it has to be, settlement has to be for 3 years. And, my lord, there is also a clause for renewal. So this was the, my lord, generally the rules holding the field. Now, here in the instant case, and my lord, sorry, I have missed out. And coupled with, my lord, the rules of 2009, government from time to time formulated policy decisions. So wherever the rules are silent, my lord, this is being supplemented by the policy decisions. Now, there were two policy decisions after 2009. One was in 2010. Now, 2010, perhaps, my lord, what the government wanted to do, government wanted to do with all the existing, my lord, private Weighbridges, and wanted to set up, my lord, integrated check gate cum Weighbridges. Now, this was challenged before by the interested parties, my lord. They challenged this policy decision before this Honorable Court. Now, Honorable Court declined to interfere. Matter reached up to the Supreme Court. Now, Supreme Court ultimately dismissed the SLP, but held that, yes, government can always come up with an idea of integrated check gates. Now, how many check gates they will have, it is up to them. But till they formulate such a policy, the existing Weighbridge will continue. Now, my lord, in 2018, my lord, they come up with a fresh policy decisions, my lord. Now, my lord, so far my case is concerned, my lord, after the rule came into force, in 2017, your lordships, in 2016, in fact, tender was floated. Tender was floated from the interested parties for operating the Weighbridge, for installing and operating the Weighbridge. Lordship will take note here, my lord. It's not that the Weighbridge already in existence,
yes,
and we are inviting, and government had invited, my lord, tender from the parties having Weighbridge. No. What the government is, anybody having suitable plot of land, the specifications were there, they can submit their bids. So, my lord, I submitted my bid. I had
Weighbridge means constitutes of the weighing platform and what's integrated with it?
Integrated Weighbridge, my lord, that's what I'm saying. Weighbridge come integrated check gate means, my lord, a vehicle, my lord, it is mandatory for all mineral-laden vehicles to enter if they are traveling in a specific route.
Everything in one place.
Yes, your lordship. They will have to enter those government notified check gates, my lord, Weighbridge. The weighment will be done. After the weighment is done, my lord, sleep is prepared by the lessee. Then the enforcement staffs are also stationed there. they will countersign. They will verify and countersign. Now, on the basis of this receipt, because these will quantify the amount of minerals the truck was carrying. So, on the basis of this, my lord, royalty is collected. So, it has a, my lord, huge importance otherwise, your lordships. So, my lord, that's how, what is the meaning of, my lord, integrated Weighbridge come, check it. Now, my lord, 16, my lord, notice was invited from interested parties willing to set up, your lordship will take note of that, because this will be a relevant issue, my lord, willing to set up Weighbridges. So, I submitted, because I have a suitable plot of land, my lord, adjacent to the particular area, particular highway. So, I was selected. These are not disputed, your lordships. So, the government ultimately entered into an agreement. Now, that agreement was, my lord, dated 7 December 2017. Now, here I will take my lord. 2017. The first agreement, my lord. 7 December 2017. If I can take my lord to that. Page 39, your lordship. The recitations, my lord, recital of this agreement is very important, your lordships. The
recital of?
Of the agreement, my lord.
Page?
Page 39, Annex 5, my lord. If I can read it, your lordship.
Yes.
This agreement is made and executed on 7th day of December 2017 between, lordship will kindly take the Governor of Meghalaya, represented by the Commissioner Transport Department, Meghalaya, Shillong, hereinafter referred to as government, with the expression shall include his successor in office and assigns the first part. Lordship will kindly take note. Well, this is a huge bearing. So this was an agreement, my lord, might have been signed, my lord, on behalf of the government by the Commissioner in Transport, by the government, in the name of the Governor. Now, why, my lord, I am stressing on this thing, your lordship? Your lordship is fully aware about Article 299. Now, my lord, state executives are at liberty, my lord, to enter into a contract. They have been given the liberty. So, if they enter into a contract, my lord, specifically say, it should be in the name of the, if the state government is entered, it should be in the name of the government. If it is Union of India, it should be in the name of the President. So, my lord, what I want to drive home here, your lordship, this was an agreement between the government and the private lessee. Only thing, my lord, the Commissioner in Transport, he was representing the government. Now, I'll come, your lordship, policy decision, because who will enter the agreement rule is silent. Now, policy decision say, it is the, my lord, Commissioner and Secretary, a Commissioner of Transport. Now, my lord, and then these I will skip, my lord, not relevant. Now, if I can take, my lord, to next page, my lord, 40. 40, my lord, second subparagraph. And whereas the licensee had, besides others, submitted his application for the said purpose, this is referring to the tender, and her application having fulfilled all the stipulated criteria, was duly accepted by the government, and the licensee was given permission to set up Weighbridge at Amsarin, Juai, Dauki Road. Because these will be passed on, my lord, what is repeatedly being said, permission is required. Obviously, my lord, here I was selected as the most suitable bidder. I had a plot of land. There was no Weighbridge. So found me most suitable, being selected, my lord, government has granted me permission to set up the Weighbridge.
Where is this place, Amsarin?
Amsarin, my lord, is Juai Dauki Road.
Here, Dauki or near the Juai?
They call it Juai Dauki Road. Juai Dauki Road. Now, my lord, this was for
limestone here.
Lordship.
Or coal also?
Yes.
Coal, don't know. Coal also.
My lord. And my lord, if your lordship comes to the next paragraph, my lord, the amount was mentioned. And whereas on completion of the construction and installation of the said Weighbridge, the government hereby enter into this agreement with the licensee 7 December for utilizing the said Weighbridge for the purpose of weighing goods, transports, vehicles to deter overloading and for collection, etc., on payment of a government approved amount of rupees 25 lakhs, only per annum to the government by the lessee, to be divided into 3 monthly installments 8,33,000 such and such by the 7th day of following English month. Now here also, my lord, I will pause for a while. These amount do not depend on negotiations, do not amount on what the person is quoting. This amount is regulated by that rule of 2009. Now, rule of 2009, my lord, is a per truck, this is the amount. So initially, my lord, it was 150 or 100, my lord, 2009. Then, my lord, small vehicle, it was 50. It was like this. 2015, there was an amendment. Rule further say, if you want to change this amount, what requires not a notification? Rule needs to be amended. Though that is something very strange. That should have been, my lord, allowed to be done by a notification, but the rules are like that. 2015, an amendment came. The amendment has enhanced the amount from 150 to 200, smaller vehicle from 50 to 100. And further, my lord, this agreement categorically say, if the amounts are raised per vehicle by an amendment, then of course, my lord, the annual lease amount also proportionately will be raised. Where is that one here for the period? Huh? Point number? My lord, if your lordship come to, my lord, page 41, clause 2, the agreement shall commence from 7 December 2017 and up to 6 December 2020. This is an admission, 6 December 2020. So, my lord, I was running it. I was paying all my payments, other thing, my lord, in time. Now, my lord, in 2020, your lordships, December, my lord, prior to the expiry of this lease agreement, one of the conditions in the lease agreement is, if I can take, my lord, to my lord, clause 1 again, sorry, my lord, 41, page 41, you say how to apply for renewal. The license shall remain valid for a period of 3 years, which is in accordance with the provision of Rule 7 of the Meghalaya Installation Regulation etc. rules and 2015, but will be subject to revalidation on yearly basis as to full payment of annual fee of 50% share of the total payment fee, which shall be examined by the Commissioner of Transport at the expiry of 1 year. In the event of any default, the payment of the licensee of the government dues the operation of the Weighbridge as per the rules provided thereon. This agreement shall be terminated for them. This is regarding non-payment, my lord. Now, regarding renewal, your lordship, my lord, will come to page 45, clause 17. The application for renewal of license, if any, shall be made at least 2 months before expiry of the license in writing. In the absence of consent in writing for renewal, the first party of the agreement shall terminate exactly after a period of 1 year by efflux of time. So they speaks about the renewal. It has to be made 2 months prior to the expiry. Now, my lord, these have first they have referred to Rule 7. So what I am trying.
3 years, then why 1 year?
Lordship. No, validation, no, that validation after 1 year. That is, my lord, they will check, commissioner and secretary will see, my lord, whether the dues are paid, my lord, all the dues are clear. Suppose the dues are not clear, my lord,
now, see,
it will be terminated earlier.
In the absence of consent writing. Okay.
Lordship. Now, my
I
lord.
don't understand. The agreement shall terminate exactly after 1 year. Why? If in the absence
They says, my lord, if there is no application. Suppose there is no application. This is the only meaning possible, my lord. If there is no application.
The renewal, if any, shall be made at least 2 months before the expiry of license in writing. Okay, fine.
Lordship.
In the absence of consent in writing.
For renewal.
For renewal by the first party, by the government. So
but
even if there was no consent, you can run it for another year.
That's what is going to be. This is what is good. This is the meaning, my lord. I looked into it, examined it thoroughly. If it is not done, consent is not given, my lord. Normally, what happens, your lordship? If a renewal application is filed and no order is communicated in writing, then it is deemed, my lord, under deeming provision, it is deemed, my lord, that the renewal has been granted. The granted means for 3 years. But here they have clarified that even if we do not make any communication, then what follows? 1 year you can run, after that it ends. This is the meaning of it. Now, my lord, what I want to drive home, these clause and the clause number 2, they are talking about Rule 7. Because what I want to say, this is a statutory contract. This is just not a contract. Number 1, statutory contract.
Why is this statutory contract?
Well, this is governed by the statute. They themselves are saying, your lordship will kindly come back to clause 1, page 41.
By the rules?
Yes, it's governed by the rules. This license shall remain valid for 3 years, which is in accordance with the provision of Rule 7. Rule 7 speaks about the renewal. So, my lord, this is not in dispute, my lord, that this is a statutory contract. So, my lord, I continued. Now, what happened, your lordships? Before the expiry of my term, my lord, supposed to expire, my lord, on 6 December 2020. Well, before that, my lord, I filed an application as per the requirement. Because this was the requirement of the rules also. I filed an application with the requisite fees for renewal. Now, my lord, there came, my lord, in 2020, my lord, what happened, your lordship, is revere, my lord. This COVID-induced, my lord, restrictions and other things, my lord. My lord, there were no communication came from their side. And there was total disruptions. Initially, they have issued an order, my lord, temporarily allowing me to run it for further 3 months. I have annexed that order also. And thereafter, my lord, there were for some period, my lord, it did not function at all. This situation continued, your lordship, throughout the COVID periods. Now, those facts are not disputed. They have also, my lord, considered in this. During the COVID period, there were some either stopgap arrangement, and it was not functional for some. So that is not in dispute. Now, my lord, what happened, your lordships? This was the situation, my lord. There was no communication from the government. Situated thus, my lord, the present writ petitioner, my lord, approached this honourable court by filing a writ petitions. And, my lord, similar writ petitions also filed by 2 other lessees of different locations. So, ultimately, my lord, the government filed an affidavit in that case. That's very important, your lordship. Government filed an affidavit. And in that case, my lord, commissioner and secretary. Now, commissioner and secretary, my lord, who is otherwise the authority named in Rule 6 for permission. What the rules say, satisfaction will depend on the satisfaction means satisfaction of the commissioner of transport. So once he processes the paper, then it has to be brought to the notice of the secretary of transport. Well, so that question will come. So that affidavit, your lordships, was filed by commissioner and secretary who was a party, yes, and the commissioner of transport. Now, my lord, I have annexed this. Which rejoinder. If your lordship kindly comes to our rejoinder, my lord. Page 14, your lordship, annex 3. Page 14, Annex 3 of my rejoinder affidavit.
Yes.
My lord. Now, lordship will see, my lord, this is 2 of 21. I see Israel in this and such and such. My lord, paragraph 1. I have been arrayed as respondent number 5. My lord, this is typographical. It should be 3. But there are 3 parties. Chief Secretary, Commissioner and Secretary of Transport, and Commissioner of Transport, not 5. 5 in the instant, 3 in the instant institution have been served with a copy of this. I have read and understood the contents thereof, being conversant with the facts and circumstances of the case. I am swearing this affidavit on my behalf and on behalf of the respondent number 2. This is the competent authority, Mr. Secretary. It's not by affidavit only by him. Now, my lord, most important part is 5. That the statement made in para 8 are correct with regard to the mention about the provision of the rule, and the petitioner is advised to approach the transport department for favorable renewal. My lord, lordship will take favorable renewal. So they have made up their mind here that these will be done. Favorable renewal, which will be considered taking into view the provision of Rule 7. Now, they admit here, my lord, all this renewal contract has to be governed by Rule 7 of the Meghalaya Installation, Regulation, Maintenance, Operation, Weighbridge, and point 2.3 of the Meghalaya State Policy for Weighbridge 2018, and after scrutiny of records and documents related to payment of all government dues. In the facts, also stated that recently the government has accepted the petition for extension of lease agreement in respect of Majai Weighbridge, East Khasir. So, my lord, here they have virtually, my lord, they have expressed their mind that yes, we are going to do it favorably in an affidavit. It's not that I am making a submission. So, that we are going to consider it favorably as per the rules, and what we will look into it, the records that your payments are up to date. Now, my lord, relying on this, lordship, Relying on their affidavit, my lord, and the statement particularly made in paragraph 5, Lordship passed an order, page 59, my lord. Page 59, my lord. Annexion 9, dated 9/5/2022. Well, 3 writ petitions were disposed of by same issues were involved. This is dated, my lord, 9/5/2022. These batch of writ petition have been filed for renewal and continuation of the existing agreement between the state and the petitioner for running the Weighbridge. It appears that the petitioners are still running the Weighbridge, and as per the affidavit of the state respondent, as indicated in paragraph 5, the renewal of the petitioner license will be considered in the event that an appropriate application is submitted before the state respondents. So the statements, my lord, made in the affidavit, that became a part of the order passed by my lord. Lordship has taken note and become part of this order. In view of the circumstances, the affidavits placed by Mr. Sungster and such petitioner submits that the writ petition can be closed. Accordingly, it is directed that the writ petitioner to approach the state respondent with an appropriate application within a week, which is considered expeditiously, preferably within a period of 1 month from the date of receipt of this. Now, other part, my lord, there are certain directions. Approach the court, file a fresh application. That came from this order. And they were brought under the obligation to decide it expeditiously, in any case, preferably, my lord, within 1 month. So there were certain clear categorical direction from this honorable court, my lord. My humble submission, which the respondent were, my lord, under obligation to discharge. Now, your lordship, the next page, 6110, your lordship, Annexion 10. That's how they started processing it. 30th May, yeah, my lord.
Yes.
22. Honorable Court of Meghalaya, while passing the judgment in such and such, such and such, such and such, has directed the petitioner to approach the state respondent, that is the Transport Department, with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy of his order. The Office of the Commissioner Transport Shillong thereafter received a copy from the petitioner on such and such, which has been processed and forwarded in original to the Transport Department. Lordship will take note here, that question of permission, Transport Department from his Commissioner, Secretary, my lord. This was processed, sent to the Transport Department. On 11th May, by letter dated such and such, such and such, such and such.
Affidavit here. It's the respondent.
Yes, they have filed. They have filed, and I have filed a rejoinder also. Small rejoinder, my lord. Therefore, in order to comply with the direction contained in the Honorable Court's order, petitioner is hereby directed to pay the renewal fee of such and such, such and such, such and such, for such. Now, my lord, here, my lord, I don't know, in the first round of litigation, some reservations, my lord, even it came from the courts, that we have never given a direction, you settle it. But there was a certain direction. What was the direction? Consider. That was the direction, my lord. So it is in that concept.
Only the
expeditious.
The way the words have been used is as per direction.
My lord will see, my lord, whether this process was well within the knowledge of the Transport Department or not. Now, my lord, Lordship has also given a direction expeditiously. This is a direction, my lord. This casts an obligation, my lord. It cannot be taken lightly, preferably with. So, my lord, this Transport Department accordingly, my lord, reflected this in its order. So, my humble submission is not that going beyond the order passed by this Honorable Court, a settlement has been made. That's not correct. And secondly, your Lordship is categorically say files were processed, sent to the Transport Department. Now, Lordship will kindly come to the bottom. Copy.
Yes.
Deputy Secretary to the Government of Meghalaya Transport. It has gone to the Transport Department. Now, my lord, ultimately, my lord, they executed an agreement, my lord, page 64, my lord, Annexure 12. Dated 1st day of June 2022. Now here again the recital is ditto the first agreement. Even the first agreement, my lord, on behalf of the government, who signed, my lord? Commissioner of Transport. Now this is also, my lord, the recitation is same. It is in the name of the governor. That is between the government of Meghalaya and the private lessee, signed by the Commissioner of Transport, your lordships. Now, my lord, Lordship will calmly come to page 67, my lord, the duration of this list. Clause 1. Clause 1, my lord. The license take effect from 1st June 2022 and shall remain valid for a period of 3 years from the date of commencement. The agreement shall stand concluded on 31st May 2025 by efflux of time. Now, regarding the amount, my lord, one submission in the first round, I'm just saying he will meet again perhaps 25 lakhs. Now, this is for the reason, my lord, why the amounts remain same. The reason is this thing, my lord, rate chargeable, my lord, remain the same. It's not amended. Had it been amended, there is a stipulation, then proportionately the lease amount also would be changed.
So it's not in the constitution, no other constitutions, only if the rule prescribes.
Rule, my lord. That I'll take my lord to the rule. That is something strange. He should have been allowed to do by a notification. He said, and 2015 they have amended by me. That is also there. I have annexed. And that is what they have mentioned, your lordship. Lordship kindly can come to page 69. Rate as per the rules. Clause 6. The payment fee only shall be realized by the licensee at the rate notified by the government number such as per the Meghalaya installation regulation maintenance of Weighbridge rules. 150-200. This is exactly ditto after the amendment of 2015. Now, my lord, once this agreement was made, I was in charge. I was operating the Weighbridge. And lordship will kindly, my lord, one more, my lord, relevant clause is there regarding enforcement. 19. Lordship will kindly come to page 74. Well, this is the integrated check gate come, my lord, Weighbridge come check gate. 19.
No, I mean, coming to the brass tacks, Mr. Sen.
Lordship.
The thing is that they have not said yet discontinued. This agreement has not been annulled.
I'll come to them. My lord, that's my case. And once that is withdrawn, so facts are almost I have finished.
Agreement subsisting.
Exactly.
But they have impeded your operation by removing enforcement.
Exactly, my lord. This is what is 19. That's why, my lord, I want to take your lordship to 19. If I can just read a small paragraph. The licensee shall issue receipt of payment fee, each good-laden vehicle signed by the driver licensee and duly countersigned and sealed by enforcement inspector, assistant inspector, the printed copy of the form, etc., etc. So, my lord, without this enforcement, my lord, I cannot function. So that is very important, my lord, because this is a Weighbridge come integrated check gate. Now, my lord, I was running it. I was making all the payment in time, your lordship. There is no dispute with regard to that. Now, my lord, on 14 July 2023, a letter was issued. That is at page 85, Annexure 14. Very strange. Addressed to me. That was issued by the Commissioner of Transport. You are hereby informed that the agreement for operation of the Weighbridge at Amsarin is extended up to 39/23 as conveyed by the government in their letter number 26/23. Now, my lord, there is something very, very strange, very confusing. They are saying now extension is only up to 39/23. Now, which agreement? My lord, which agreement? Now, my lord, what is the reason? If they wanted to, what, my lord, has been argued in the first round of litigation, no permissions. My lord, if there is an agreement, my lord, subsisting, statutory agreement, if the government want to say, okay, sorry, that has been done irregularly. Now, what about the rule of odi alteram partem rules, principle of natural justice?
Yes.
The shock cause is not required. These were, even if not a shock cause, my lord, have they spelled out how it happened in this agreement? They were silent, simply issued an order, no, it is only up to this. And they have referred to a government decision contained in letter dated 26/23. Now that also I have brought to the brought on records, my lord, in my my lord rejoinder affidavit, because I was expecting at least in that letter they will cite some reason. These are the reason it has been done irregularly, so we are correcting it. Even that would have been wrong, because that would have been without giving me an opportunity. Now, my lordship can look into this. My lord, in my rejoinder, my lord, that letter which they have referred to, page 10.
Oh, we have to reply.
Well, not page 10. Not page 10. No. This is page 13, Your Lordship. 20th June 23. So this is also from here.
What affidavit are you talking about?
My rejoinder, rejoinder affidavit, Your Lordship.
4th March 2024.
Yes, 4th March 2024.
Just filed yesterday or day before?
Day before, Your Lordship. Monday. Now, my lord, this letter which they have referred earlier, my lord, is 20th June.
Filed. Oh, yes, got it, yes.
20th June 23. Now, this is from
page 10.
Page 13, Your Lordship. Page 13, such and such. Now, my lord, subject. Now, my lord, this is from the, my lord, Transport Department to the Commissioner of Transport. Renewal of license for Weighbridge of Amsari near such and such. Such and such, such and such. I am directed to refer to your letter on the subject and cited above and to inform you that the government has conveyed its approval for extension of the agreement up to 39/23 only and no more extension beyond the mentioned date. Now, what is the reason? If it has been done irregularly, they could have spelled out it has been done irregularly, or they could have issued a shock cause. Nothing. No reason has been spelled out. Now, my lord, being aggrieved, I filed, my lord, the writ petition in the last year. Before the, my lord, the deadline was, here in this case, the deadline was, my lord, 39/23. So, well before, my lord, 39/23, I filed a writ petition, my lord, assailing this order, my lord, truncating it to 1 year, up to 39/23. I was challenged. On the very first day of motion, my lord, and I was reading out, Lordship questioned, my lord, how court has never given direction. This is not the case. This is not the case, never the case of the government. Had it been the case of the government, they would have spelled out. Then an agreement has been made, misinterpreting the order of this court. And I'll say, my lord, with confidence, even right now, my lord, there is nothing on record, man, that this has been done by misinterpreting the order of this honorable court. Now that had, my lord, court can always, my lord, make searching inquiry, my lord, whether there is a contention raised or not. Lordship has raised that issue. And on that day, Lordship declined to pass immediately any interim order. Asked the government to file an affidavit. Now they filed an affidavit and they have elaborately taken up the problem, misinterpretation, repeated misinterpretation, taking the cue from the court.
Yes.
They could have, my lord, substantiated it by, my lord, producing relevant records, that this was there in the record, that this was misinterpreted. They never did that. And then, my lord, ultimately, your lordships, in that petition, my lord, 299, first round of litigation, this is what, at page 93, my lord.
In?
Page 93 of my writ petition,
Yes,
present writ petition. Now, ultimately, on their filing the writ petition, my lord, and the matter was heard at length, your lordship. Lordship had initial intention to dispose of the entire matter. But after hearing at length, lordship has passed this order, 28/9/23.
Yes.
The matter was heard at length, but however, the same could not be concluded. It is noted that the petitioner, who agreement dated 1/6/22, entered into with the respondents for utilization of the integrated check gate cum Weighbridge at Amsari and Jawai Dauki Road, has approached the court, impugned an order dated 14/7/25, whereby the agreement has been extended to 39 instead of being allowed to run till 31/5/25. As the matter needs further detailed consideration, and as the term as per the impugned order is to terminate on 39/23, it is provided in the interim the status quo as on today shall maintain until the next date. List this matter on such and such date. So, lordship, well, at least 2-3 days before, my lord, the deadline, passed this interim order. And this has been extended from time to time. For some reason, my lord, hearing could not be taken up. And ultimately, the last order your lordship passed, page 95/19, my lord, on 8/12/23, just before the vacation. In the course of hearing, it has been seen that the communication letter referred to in order dated 30 May 2022 appended an Annex 9 to the writ petition are necessary for proper adjudication of the matters. These records are necessary as prima facie it appears that the order of this court dated 9 May 2023 has been misinterpreted and misconstrued. The lordship called for certain records to ascertain this situation. accordingly list this matter on reopening court on 29 January 24 for further hearing and production of records. Interim order shall continue till the next date. So this was the order, my lord. The vacation commenced. Now, during the vacation, what happened, your lordship, on 16 January, what they did, lordship, is the next page is the order. Yes. They had withdrawn this impugn order, which was, my lord, specifically under challenge in the first round of litigations. And that too, they have referred to lordship's order. My lord, 2096, 16 January 2024. With reference to the subject cited, letter number cited above, I am to inform you that in view of the High Court's order Meghalaya dated such and such, petition number such and the order dated 14/7/22 referred to above is hereby withdrawn. My lord, matter ends here. What was under challenge? This order truncating the period up to 1 year instead of allowing me to run till 25, number one. Lordship has taken up the exercise, very categorically mentioned to ascertain how it has been done. The issue was pending before the court. They had withdrawn. Now, my lord, what are the consequences of this withdrawal, my lord? This is very clear, my lord. The agreement executed.
Restoring it back what it was before.
My lord, it come back into force. It come back into force, your lordship. That has never been cancelled otherwise, your lordship. Come back into the force. So I was under the expectation now I would run it. But strangely, my lord, on 29, the matter was not taken up, the lordship was not sitting. So I have had, my lord, mind to inform the court the matter has become infructuous. But on the 1st February, my lord, strange thing happened. Without any formal communication, without any shock cause, without even calling me, your lordship, they had withdrawn the enforcement staff and relocated them in a nearby, my lord. Overnight it became functional, a government Weighbridge, just 2 kilometers away from Amsterdam. The intention was very clear and categorical. If this petition remained pending before the court, perhaps we won't be able to do all this mischief. Take this case, get this matter closed, then we will do. Now they have virtually, my lord, relocated them, closed down my Weighbridge. If the enforcements are not there, my lord, I cannot function. So immediately, my lord, on 2nd, I took lordship's permission and moved the unlisted motions. But my lord granted them some time. After this matter was heard, lordship passed an order. It requires final disposal. But lordship has, even in the interim, held, my lord. This calls for some interference. Lordship has held, my lord. But anyway, I was in a very desperate situation, my lord. My client was in a desperate situation. His Weighbridge has been closed down. In spite of the fact, my lord, the order was withdrawn. We preferred an appeal, your lordships. Now, the division bench, considering the fact, taking note of this, all the contention raised by the rival parties, my lord, and that lordship has fixed the matter for final disposal, declined to pass any order. Instead, my lord requested the court that the matter would be disposed of. Would be disposed of by your lordship. Now, my lord, my legal submission now, my lord. First contention will be, my lord, shall we go into all those...
one thing, Mr. Sen.
Lordship.
You'll have only, we have a certain meeting with some government at 3 o'clock. That's the only thing.
Then we'll have to, my lord, with some citation, my lord. Some citations are there.
Carry on. I mean, till you can carry on.
Till 3, then we'll, my lord, if I cannot, my lord, will continue, my lord. Because here the first thing, my lord, instead of going into all those things, first thing, your lordship, my lord will need to take a call. What happened when that impugn order was withdrawn? Anything survives? Nothing survives. I understood, my lord, in the first round of litigation, many questions were raised. Permission, misinterpretation of courts, or all these things were raised. But the moment it was withdrawn, they should have waited for an adjudication by the court. They had not. They had withdrawn. They had revived the
new Weighbridge.
Yes. My lord, the instruction I got is by the government, but the beneficiary is somebody else. But since I do not know, my lord, the name and all, my lord,
I don't know. You should.
My lord, the kind of things are happening. This is the instruction I have received. Beneficiaries are there, but namesake it is the government. They have done it. Now, my lord, need to take a call, my lord. Moment it was withdrawn, my lord, everything ends. That writ petition became infructuous. But that was the issue before the court.
No, that's what that was what the.
That is the most disturbing. That was withdrawn.
Yes.
Exactly.
That is a new cause of action entirely. The other one is that
exactly,
the matter is restored back to what it was.
Right. So, my lord, what I am saying, because they have raised the same points again. Now, they are raising, moment it is withdrawn, my lord, gone. There is no scope of, my lord, examining that. Why it has been cut short. They had withdrawn. They have revived and they have never cancelled my agreement. It remains. So I am supposed to run, but on the first they had withdrawn the enforcement. So I challenge this action, my lord, in the present writ petition. Now, number one, your lordships.
See, the thing is that you have to allege sort of malified, because now the only one clause you said that agreement says that the countersigning of the enforcement directorate or enforcement personnel.
Right.
Now that means that they've totally disabled your Weighbridge. Whether it's incumbent upon them to propose officers, or whether can a manifest issue that they should be posted there.
That for that, your lordship, whether the contract is governed by a statute. If it is a statutory contract, my lord, normally what happens, my lord, it belongs to the, my lord, private domain, purely a private contract, simply says, writ court will not exercise the jurisdiction. So this is, my lord, apparently from the recital, is a contract between the government and the lessee. That is obviously, my lord, the source is 299. Admittedly, my lord, governed by the statutes. Those decisions I have. If it is statutory, lordship will enforce.
So we need to examine that part.
Exactly, my lord. Those I have. Those I have, my lord. Now it became infractuous, my lord. The first litigation obviously became infractuous. Now, my lord, shall I have to answer now the other question, because I have seen their affidavit. Ditto the same stand they had taken in the first round of litigations. Now, need I have to answer this? I am ready to answer this, my lord. They have raised, number one, misinterpretation of the court's order. Now, here your lordship will see, my lord has passed an order taking into account a statement made by the secretary, the authority named in Rule 6 to grant permission. And that is to an affidavit and by the Commissioner of Transport. Now, on the basis of this order has been passed. There was never any initiative. Had it been wrong, then there should have been an initiative from the government to expunge it. Now, my lord, High Court, under Article 215, Court of Records. Now, what is this Court of Records? I have got a decision. Once the court decides, whatever is in the records, what is the evidentiary value? These will hold good in all subsequent proceedings. Nobody can question. Now, virtually saying that these are not correct, my lord, they are questioning the records of this court, whatever is there in the records of the court, my lord. Is it permissible? What is that evidentiary value? My lord, on this Court of Records, my lord, if I am required to answer, my lord, this, because they have raised, but I need to answer, since they have raised, I will answer it to your lordship. My lord, I have referred to, my lord, referring to a decision of 1998, 4 SSC, page 409. 1998, 4 SSC, page 409. Para 12. Para 12.
It's a constitution bench.
This is, my lord, constitution bench. If I can read, my lord, para 12. Para 12 say, my lord, at page 419, a court of record is a court, the record of which are admitted to be of evidentiary value and are not to be questioned when produced before any court. The power that the court of record enjoy to punish the contempt is a part of their inherent jurisdiction, essential. So, my lord, here basically, my lord, what I am saying, my lord, once it is a part of records, my lord, unless it is expunged, reviewed, well, if they want to say these were inappropriate statements should not have been made, my lord, something is wrong there, they should have approached this court for expunging that. Never happened. Now, my lord, they cannot question it.
Yes.
And lordship has duly taken into note that paragraph 5. And paragraph 5, the secretary is saying, favorably, provided your records are all right, there are no dues. Well, admittedly, in my rejoinder, I have said there was no dues, so far I am concerned. Lordship will continue, it's going to be 3, my lord.
Oh, yes.
Well, I'll continue. I won't take much more, another half an hour, your lordship.
Tomorrow?
Let it be tomorrow, no problem.
Let my friend. But I will be, my lord, I will be addressing your lordship on Tuesday, my lord. Let my friend finish his argument so that whatever judgment my friend is citing.
Actually, the course mentioned the law part. Because we understand
both aspects are there, my lord. On fact also, fact because he has not challenged the order of the government of June 2022, my lord. That order is not under challenge. Government order is not. Communication order is challenged. Government saying that no extension, that order has not been challenged.
At least he has changed the track now. Changed
the whole dimension of the case.
The track has been changed.
You examine that, Mr. Sen.
Well, what I do, this was a government, this was never addressed to me. This was the internal communication.
It was in his knowledge, he has relied upon it.
Now I have got it, I have a next.
Knowledge, once
this
it
is not addressed to me.
Order.
Yes, sir.
But anyway, the new ground, my lord.
Third and part, he had to continue tomorrow.
Tomorrow.
Qualified to 3. So, 1 minute. 1 or 2 minutes.